Well, my man MoneyBoy Trey in the building. He said, hit that like or we gon' fight. Make sure you check him out on YouTube.
Hello. Let me talk to the host. The host is MoneyBoy Trey. What's popping?
Will you interview with at MoneyBoy Trey?
Or MoneyBoy Trey is back. Where you been?
MoneyBoy. You see me in they chats because that's the circle that I associate with.
MoneyBoy said manhood is subjective. No, the fuck it's not.
Okay, very good. Welcome back. Everyone have a seat. Welcome back, members of the jury. I do know that one of you has got a special event this evening, so I promise you we will break before 5. Okay, not to worry. All right, very good. State, do you wish to call a witness at this time?
Yes, Your Honor. The state of Florida calls Dr. Julio Warner.
Okay.
Do you solemnly swear or affirm that the testimony you're about to give in this caution is the truth, the whole truth, and nothing but the truth, said here? Right here.
Good morning.
Good morning.
Would you please state your name?
My name is Tonia, Tonia Warner, Werner.
Ma'am, how are you employed?
I am employed at Meridian Healthcare in Gainesville, Florida. It's a community mental health care center.
Okay, and what do you do there? What is your position there?
I am Vice President and Chief Medical Officer.
Can you tell the jurors your educational background?
Yes, so I graduated from the University of South Florida with a degree in chemistry. I then graduated from American University of the Caribbean with a medical degree. I did my psychiatry residency at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. That was 4 years of training in general psychiatry. I then came to Florida and did a 1-year fellowship in forensic psychiatry at the University of Florida.
And can you, from that point, take us forward through your work history?
Yes. So at that point, I was asked to stay on faculty at the University of Florida, and I remained there for 18 years on faculty at UF until I retired from there in 2015. And at that point, I was the vice chairman of the Department of Psychiatry, the chief of the Division of Forensic Psychiatry, and the head of the Forensic Institute at the University of Florida. The next day, I went to work as the vice president and chief medical officer at Meridian Healthcare, and we provide primary care services, mental health services, and substance abuse services for North Central Florida, mainly for individuals who are underinsured or uninsured.
And would that be considered primarily a clinical practice?
Yes.
Okay. And do you also, since you have experience in forensic psychiatry, do you also do consultations in the forensic area?
I do.
Right. And doctor, do you hold any board certifications?
Yes, I'm board certified in general psychiatry and in forensic psychiatry through the American Board of Psychiatry and Neurology.
And can you just explain, if you could, to the jurors the process to obtain your board certification?
Yes. So in the past, we had to do a written examination and then an oral examination for the general boards. And then the forensics boards was just a written examination. Now it's changed, and I think we have to do every 3 years, we have to do update and do some testing, read some general articles and do some testing. And you can opt into that program and do some peer reviews and have peers review some of your work, send them some of your notes and things like that. or you can still do the test every 10 years to maintain your certification.
Are you licensed to practice medicine here in the state of Florida?
Yes, sir, I am. I have been licensed in the state of Florida since 1998.
Prior to working here in Florida, did you work or do forensic evaluations in another state?
I did. I started my forensic work in 1996 in the state of Connecticut while I was at Yale University.
Are you a member of any organizations or societies that deal with forensic or general psychiatry?
Yes, I'm a member of the American Psychiatric Association and the Florida Psychiatric Society. I'm a past elected president of the Florida Psychiatric Society. A member of numerous different committees for the Florida Psychiatric Society, including presently I'm the chair of the ethics committee for the Florida Psychiatric Society.
Can you explain to the jurors what the field of psychiatry deals with?
So psychiatry basically deals with brain diseases that affect how an individual thinks or behaves.
And the subfield of forensic psychiatry, what does that area of medicine deal with?
So that area deals with anywhere where psychiatry intersects with the law, whether that's in a criminal case such as these or in the civil arena, personal injury, contested wills, any number of areas in the civil arena.
Can you explain to the jurors the difference between psychiatry and psychology?
Yes, so a psychiatrist has completed medical school such as myself and can prescribe medications. And a psychologist has a PhD or a PsyD. They have different stipulations with regards to psychologists. But they can't prescribe medications.
Your work as a consultant in forensic psychiatry, how long have you done that here in Florida?
Since 1998.
Since 98, okay.
Yes,
Would that
sir.
be generally when you came here?
Correct.
All right. And through that part of your practice, do you consult on, well, you obviously consult on legal cases. Do you consult on both civil and criminal cases?
I do.
In criminal cases, can you tell the jurors the type of issues you deal with?
Yes, so the majority of them are probably competency to proceed. That's very common. So do they understand the court process and can they assist their attorney in going forward with their case? Do they understand their charges? I also do sanity at the time of the crime. I have done also competency to be executed. I've done those for defense and been appointed by the governor to do those.
And are you, in fact, appointed by the governor to a board of psychiatrists to perform those competency evaluations?
Correct. There's a committee or board of 3 psychiatrists appointed to do that when that happens.
Okay.
Correct.
Have you previously testified in a courtroom like this as an expert in the area of forensic psychiatry?
I have. Yes.
Approximately how many times?
Numerous times. Probably hundreds.
Okay. And in what jurisdictions?
From Key West to the Panhandle, like all over the state of Florida, New York, all up and down the East Coast, Connecticut, all up and down the East Coast, basically.
And have you appeared on behalf of the state of Florida in a situation like this before, or been consulted with the state of Florida in a capital murder case and testified in a penalty phase proceeding?
I've worked for the prosecution and the defense in cases such as this.
All right. And that was my next question. So you have
Sorry.
worked, that's okay. You've worked on both sides of the courtroom then.
Yes, absolutely.
Okay. In cases such as this, when you've been retained, in this case, you were retained by the state of Florida, are you provided materials and will you seek out additional collateral materials.
Yes.
Why do you do that?
Just because to formulate an opinion, you want to have as much information as possible. If something's missing, I want to ask for that. If I see something in another expert's report that I didn't see or I didn't have access to, I'll ask for that. And I did that in this case. Mentioned some things that I saw in Dr. Eisenstein's report that I didn't see. So, inquired about those. So, yeah, you want to have all that you can have to be able to formulate your opinion.
Okay. And what would be the benefit of looking at law enforcement reports, police reports, interviews of a person that you may be evaluating?
All of that has to do with the individual's thought process, their adaptive functioning, what they're doing, how the whole process, what went into, the instant offense. I mean, that's why we're involved in the first place.
In this case, were you provided materials by the state of Florida?
Yes.
And did that include law enforcement reports dealing with the investigation, in this case from the Tampa Police Department?
Yes, it did.
Did it include investigative reports from the Jacksonville Sheriff's Office?
Yes, it did.
Did it include audio video evidence of both the crime scene areas and places within the city of Tampa before and after the crime scene, and audio video interviews?
Yes, there were also photographs.
And photographs?
Correct.
Were you also provided with a medical examiner's report in this case?
Yes, I was.
And I believe some of the autopsy photographs.
Yes, there were autopsy photographs, correct.
Were you provided, doctor, with social media and cell phone extraction evidence?
Yes, I was.
You've already mentioned you were provided with Dr. Hyman Eisenstein's report.
Yes, that's correct.
And were you provided with a transcript of a deposition that the state of Florida took of him?
Yes, I was.
Were you provided with a transcript of the deposition of Dr. Tracy Harding?
Yes, I was.
Have you conducted some type of evaluation of both defendants Davion Murphy and Isaiah Chance?
Yes, I did.
And did that involve you meeting with them by Zoom, I believe?
That's correct.
And is that a practice that you have done in other cases?
Yes, absolutely.
Now, by Florida statute, your evaluations of these two defendants is a prohibitive evaluation until they are convicted of capital murder. Is that correct? I can rephrase.
Okay.
Are you pre-trial or before the trial starts, do you have access to interviews or evaluations of defendants?
Overruled, go ahead.
I do not.
Okay. And in this case, did your evaluations of them occur after the convictions occurred?
Yes, it did.
And is that by law?
That's correct.
Okay. So once Mr. Murphy and Mr. Chance were convicted of capital murder, first degree premeditated murder, you were then given access to be able to conduct evaluations?
That's correct.
And when did those occur?
They occurred this past Saturday.
All right. So that would have been the day after they were convicted?
That's correct.
And did that take place throughout the day on Saturday?
Yes, it did.
So I'm going to start with your meeting with Davion Murphy.
Yes,
And
sir.
before we get to that meeting and evaluation, you have talked about some of the items you were provided. Were you provided with Dr. Eisenstein's report?
I was.
Were you provided with numerous documents and records that were provided to the state from the defense?
Yes.
And did that include educational records?
Yes.
And recently, have you been given information concerning medical records?
Yes.
In your evaluation of him on Saturday, can you tell us how long you met with him?
So I met with Mr. Murphy for approximately an hour and 20 minutes.
Okay. And what type of evaluation did you conduct?
So I did a forensic evaluation, so getting just general getting to know him, and then a mental status examination.
The forensic evaluation, what does that consist of?
So it consists again of, so initially I introduced myself, the purpose of the evaluation. I do a let him know that it's not confidential the way that it normally is when you meet with a psychiatrist, because we're doing it for the court. I'm going to have to take notes and that I'll be asked to testify, so that the things that we talk about are not going to be private. Make sure that he has an understanding of that. And his attorney was present at the time as well, via Zoom. And then I go through kind of his history, talk to him about his family growing up, his educational background, work history. So just get a good, feel for him, a good background on him. I do all of that, go through his medical history, his psychiatric history, substance use history, and then do a cognitive or mental status examination.
So I'm going to start with your discussions with Mr. Davion Murphy about his family and his upbringing. All right.
Yes.
Did he give you a general description of his childhood and growing up?
Yes.
What did he tell you?
So he talked about his family growing up. He loved his family very much. He described his childhood. He was Christian. He attended church. It was very God oriented. He was very close with his family. He enjoyed his childhood.
Did you have an opportunity in the last couple of days to watch the testimony of Dr. Eisenstein and also to review the testimony of Dr. Harding?
Yes.
Okay. And you have Dr. Eisenstein's report, you said?
Yes.
Okay. All right. Did you, in your investigation of this case and your evaluation and your discussions with Mr. Murphy, did you determine if there was any history of physical or emotional abuse?
He denied that to me. I specifically asked him about physical abuse and sexual abuse. He denied that.
Can you talk to us in a little more detail about your mental status exam and exactly what you did with the defendant?
Yes. So with my mental status examination, I go through and just kind of notice their appearance. And he was dressed in orange correctional attire. His motor behavior was within normal limits. His speech was within normal limits. There was no kind of latency of response. So it didn't take him a long time to answer. When I asked him a question, there wasn't a long pause between his response and my question. He was oriented to person. He was able to give me his date of birth, his age. He was oriented to the date, the day of the week, the season. He was aware that he was in the jail on Falkenberg Road, so he was oriented to where he was. He knew that Mother's Day was the following day, so he knew the upcoming holiday. So he was well oriented to what was going on and where he was at. I tested his concentration. I gave him 3 items to remember for me. He was able to register them and give them back to me right away. And after a period of distraction, so after I do all these other things I'm going to tell you about, I asked him about them again. And I had given him the words orange, tree, and flower. And at the end of all these other things I'm going to tell you about in a second, he gave me back orange, plant, and flower. So very close. The middle one, instead of tree, he gave me plant, but he was very close with those. He was able to identify the current president, and then he couldn't recall Biden, but he said he was an old white dude, described him as an old white dude, quote unquote, and then knew that there was Trump and Obama and Bush again. So he was able to kind of name some presidents. He spelled the word world correctly forwards and in reverse, which is again a test of concentration and a test of spelling. And so he knows his alphabet. I know that was an issue and a question. Another test of concentration, I had him do serial 3 subtractions from 20. So I say, can you start at the number 20 and go backwards by taking away 3s? And he went right down, 17, 14, 11, 8, and went right down, no problem. through 6 calculations and clearly retained the task that I had asked him to do. He did a simple calculation. I asked him if he had $20 and gas was $4 a gallon, how many gallons could he buy? And he said, 5 or 6. He knew the general information. I asked him, what's the function of your stomach to digest food? If you were to leave Jacksonville, which direction would you travel to go to Miami, New York, California? He got all of those correct. Who's Martin Luther King Jr., Black leader who fought for freedom? And then I do abstract reasoning. So just testing their ability for abstract thought. How are a dog and a lion alike? He said animals. How are an orange and a banana alike? Fruit, a coat and a suit, clothes, a table and a chair. And that one he said, I don't know. And then he said to sit and eat on. So that one he gave me a very concrete answer and gave me kind of how they're used, as opposed to the response would be the correct response would be furniture is how they're alike. And then I tested abstract thought with regards to a proverb, which is what goes around comes around. And his response was karma, which is a correct response for that. So abstract thought, he was pretty good on that, other than the one response was a concrete response. And then this is when I went back after answering all of those questions and asked him, do you recall those 3 words? So after I gave him that, all those distractions and all that, went through all those, that's when he was able to pretty well recall those 3 words. So he did pretty well on the mental status examination.
And how many times have you administered that examination?
That's the same one I used in my training at Yale University back in the 1990s.
So hundreds, thousands of times?
Absolutely.
What about just conducting a mental status examination? How many times have you done that with patients in a clinical setting or people who you are examining in a forensic setting?
Oh, many, many more times than that.
Okay.
I mean, I saw patients this morning on telehealth before I left the hotel.
At Meridian?
Correct.
Okay.
Yes, sir.
Did you detect in that evaluation and in your entire evaluation anything to suggest that Mr. Davion Murphy has any kind of impaired brain functioning or damage?
I did not.
Have you ever dealt with patients or people in the forensic setting that do have brain damage or have suffered traumatic brain injuries?
I have, yes.
Okay, so you would know how to detect that, or is that something you're trained to do?
Yes.
Have you covered everything that you've done with him in this evaluation, or is there more?
No, that's
pretty much it?
Yes, correct.
Okay. Now, in your having conducted your mental status examination and your forensic evaluation of him and your review of the materials in this case, I want to ask you a few questions.
Yes, sir.
And specifically, you reviewed the facts of this case.
Correct.
And witnessed and saw the video from the offense itself and how it was executed, the crime.
I did.
The murder.
I did.
I want to ask you, do you have an opinion as to whether the capital felony in this case was committed while the defendant was under the influence of extreme mental or emotional disturbance?
I did not see any evidence of that, no.
And do you have an opinion as to whether the capacity of the defendant to appreciate the criminality of his or her conduct, his conduct in this case, or to conform it, his conduct to the requirements of law, whether it was substantially impaired?
I did not see any evidence of that, no.
Now, did you come to any opinions about Davion Murphy's level of cognitive functioning?
Yes.
And when you arrived at that opinion, did you consider the testing that you did or the evaluation?
Yes.
Did you also consider questions that you asked him about his history? Let me ask you this, did you talk to him about his work history?
I did.
What did he tell you about his work history?
So he has held numerous jobs in numerous different places. Specifically, a lot of them were in the food industry, working at different Burger King, IHOP, different places, which required a lot of kind of fast kind of thinking and fast doing. And he was there for significant periods of time, 6 months, different significant periods of time.
Okay.
And some of them overlapped where he was working at 2 to 3 different places at a time.
Did he relate to you that at some point he had moved to Orlando from Jacksonville?
Yes, he was residing with a girlfriend in Orlando for a period of time, correct.
And did he relate to you something about the expense or cost of living there?
Correct.
And did he inform you as to maintaining multiple jobs due to the cost of living?
Yes.
And you mentioned some of the duties that he did. As far as a couple of the places he worked at, I think specifically IHOP and maybe Steak and Shake, did he advise you that he worked as a short order cook?
Yes.
And would that be a position that has a timed element to it?
Yes.
Is that something you considered?
Yes, absolutely.
All right. And these things that we're discussing, would those be considered adaptive functioning?
Yes,
Now, you're familiar with the DSM-5?
I am.
And do you have a copy of it with you right there?
I have a copy of the DSM-5 TR, correct?
TR. Okay. Now that's the current edition, correct?
Correct.
All right. Is that a statistical manual that you utilize frequently?
Yes.
And in the DSM-5 TR, are there not recommendations when assessing, as a psychiatrist, when you're assessing for cognitive functioning or cognitive ability to look at adaptive functioning?
Absolutely. It's a requirement. Correct.
All right. And it specifically spells out what that is or what they're describing, correct?
Yes, it does.
In assessing his cognitive functioning, did you also look at his behavior in this case, the facts of this case?
Yes. And I took all of that into consideration.
Would that include his behavior and actions he took before the crime occurred as well as during the crime?
During and after, correct.
And in your investigation of this case, were you aware of the fact that the defendant was at large for approximately 7 months after the murder happened?
Overruled, go ahead.
Yes, I was aware that he was at large for 7 months.
Okay.
Correct.
And was able to elude capture?
Yes.
Were you aware that the Jacksonville Sheriff's Office was actively pursuing him?
Yes, I believe there were billboards and press releases and yes, correct.
Did you take that into consideration?
I did, yes.
Would that have required an adaptive behavior?
Yes, I believe he actually commented on that. Correct.
And were you aware that when he was finally arrested that he gave a approximately 2-hour interview?
Yes,
Did you review that interview?
I did.
And during the interview, did you take note of statements that he made about his culpability or whether he had been involved in the case?
Yes.
In that type of a situation, if a person is misleading or lying or being disingenuous, is that something that you would consider to be important to your analysis?
Yes.
And the types of lies that they were able to create, is that something that you would also consider to be significant?
Yes, absolutely. If they're able to manipulate facts and kind of incorporate them into their misstatements or fabrications, that's indicative that they're able to kind of fabricate or manipulate things. So cognitive comes into their cognitive functioning.
Does the DSM-5 speak to assessing for cognitive ability as far as utilizing IQ testing or standardized testing?
Yes, it's not just based on IQ testing, and you can't just use the IQ test. They can't just use the number.
And is this an area of analysis where collateral information like these police reports and the behavior of the defendant during the commission or before the commission or after the commission of the crime, where that is a significant factor that you could look at?
I think all of that is significant because it again plays into their adaptive functioning and demonstrates, adaptive functioning, just like work history, all of that comes into play. Yes, you've got to take all of the information that's available to you when trying to formulate an opinion.
Have you come to an opinion, doctor, as to his level of cognitive functioning?
Yes.
And what is your opinion?
I think that he has a low average level of functioning.
When you were speaking with Mr. Murphy and conducting your mental status evaluation of him and your forensic evaluation of him, did you consider the issue of malingering or faking?
Yes, you always consider that when you're, especially when you're in the forensic setting and in the criminal arena. Absolutely.
Why is that?
Because of the stakes involved and the setting that you're in, you're always having to look for that.
I wanted to talk to you about a few things from Dr. Eisenstein's report. When considering adaptive functioning, did you take note of the Texas Functional Living Scale that Dr. Eisenstein administered?
I did.
And some of the requests and some of the testing procedures in that test?
Yes.
So first, I'll talk to you about telling time on a clock. Was that one of the items that Mr. Murphy was requested to do?
It was.
And I guess he was asked, Dr. Eisenstein had noted he was unable to tell time on a clock, reversing the hour and minutes, and had difficulty drawing the correct time on a clock. Did you find that to be significant?
Not necessarily. We don't really use analog clocks anymore. We don't really use that type of clock anymore. They're kind of phased out. And I found it to be slightly contradictive with regards to the clock that he drew on the Mocha.
Okay.
Because he was fairly close on the Mocha. The small hand, he first put it on the 10 and then moved it to the 11, but the big hand was 10 minutes after. So the hands were fairly correct on the Mocha, although he wasn't scored as being correct on there, but he actually did the time fairly correct on the Mocha.
He was supposed to represent 10 after 11, I believe.
Correct.
Did you think it was significant that the proportions of the drawing as far as the placement of the numbers was a truly significant item to his cognitive functioning?
Correct.
Under that Texas Functional Living Scale, he was also requested to do a money and calculation subscale.
Correct.
He was asked, well, he noted he was able to count change correctly, but was more inaccurate than not, and unable to provide correct change even with the dollar bills and coins placed in front of him. Did you find that to be significant?
I don't know. A lot of people don't use cash anymore. I don't know how often he uses cash and whether that's actually significant or not. But with regards to this case, not necessarily, but a lot of people don't use cash anymore. I rarely personally use it, in all honesty, because we have the debit cards and the cards now.
In the communication subscale, and I'm going to do this as a group, he was noted to have difficulty writing out a bank check and indicated he'd never written one out.
He's never written one, so he would have difficulty doing that if he's never done it before.
He was asked to address an envelope correctly and indicated or had problems doing that, apparently. Well, it says he was able to actually do that correctly.
Correct.
And then he did not know how to look up a person in a telephone book. Did you see issues with this?
Yeah, I did not, because we don't even have phone books anymore. I don't even know the last time that I saw a phone book.
The level that you have put him at or placed him at as far as cognitive functioning,
Yes, sir.
would that be consistent with this defendant at the age of 13 or 14 taking over management of a household?
It's possible, yes. Yeah, and doing the household functionings, he would be able to kind of keep that together, correct?
Okay. So if the jury has heard that he took over the household when his mother was ill and cooked for his siblings and managed cleaning and chores and tried to keep it at the same standard his mother kept it at, would that be inconsistent with your finding of cognitive level?
No.
When you met with Mr. Murphy, did he indicate to you that he was prescribed and taking medication?
Yes.
And what medications?
He said that he was taking Buspar and Remeron.
Okay. And what are those medications and what are they used to treat?
Yes. So Buspar is medication that's used for anxiety, and Remeron is an antidepressant.
Okay. And in fact, did you diagnose Mr. Murphy in your diagnosis? I'm kind of jumping ahead here. I know you have several diagnoses. Did you diagnose him with a condition called adjustment disorder?
I did.
And what is adjustment disorder?
So adjustment disorder is a disorder that individuals can have when they have a stressor and it's related to a stressor. So clearly he's got an ongoing stressor right now with regards to this significant legal case. And that can cause mood disturbance, conduct disturbance. So, but it's generally related to a stressor, whether it's relationship discord, a divorce, some problem with your children, but there's an identifiable stressor. And typically you expect the symptoms, you treat the symptoms as you would anything else. And you expect them to kind of resolve once the stressor is resolved. So he's being treated for that right now. His symptoms related to, his stressor.
And you mentioned anxiety and depression. Would those be symptoms?
Yes.
Is that something that is commonly seen in the forensic setting with individuals who are incarcerated in a jail setting?
Absolutely. Absolutely.
And just simple depression or anxiety, is that something that is commonly seen with people who are incarcerated, pending charges, or in a case like this, possibly facing a sentence of death?
Absolutely. Absolutely. Facing any kind of sentence or, just being in jail in the correctional setting can be very stressful for individuals. Yes.
Now, you indicated that you did this forensic evaluation where you asked him about his history. Did you discuss with him his use of substances over his lifetime?
Yes, I did.
And what did he tell you?
So he described to me significant substance use, specifically with regards to alcohol, beginning at the age of 14, and his use became very heavy at the age of 16. And then he was daily use by the time he was 27, 28, where he said that he was actually drinking a bottle to a bottle and a half of tequila on a daily basis at that age. Marijuana, again, daily use, every day, all day, quote unquote, is what he told me. Up to 14 grams per day is what he told me, from 14 to 28. I'm sorry, from 11 years of age to 28, all day, every day. And then the other one that he used all day, every day, quote unquote, beginning 18 to 28 was ecstasy, which is a hallucinogen. And he described using 9 to 10 pills a day, double and triple stacks, he said. He used cocaine one time in 2016, but he didn't like it. It made him paranoid. And then he used some opioids several times, but didn't like those either. 3 to 4 times, he said, but he didn't care for those either.
Now, you're asking him about his substance use. Is that
Yes.
something that is significant in your analysis and your evaluation of cognitive functioning?
Yes.
Why?
Well, because all of those substances will impair can impair your cognitive ability. Certainly, if you're impaired on substances, that can cause you problems.
And he was indicating to you that he was using multiple substances when he would have been in high school.
Correct.
Have you come to any conclusions or opinions about his use of substance abuse and whether it relates to any type of disorder?
Yes, I diagnosed him with alcohol use disorder, cannabis use disorder, and hallucinogen use disorder.
Did you note in his history that there was some indications that he may have had ADHD when he was a child?
Yes, he was diagnosed with ADHD as a child, correct.
And as far as him as an adult now, have you come to any conclusions or opinions about ADHD and whether he still suffers from it?
I did not see any symptoms of ADHD at the present time.
Now, are you basing that on your contact with him on Saturday during this evaluation and on all the other information you have in this case?
All the other information that I have about him from the case, correct.
During your observations of the testimony of Dr. Eisenstein, Dr. Hardig, when you were watching a live feed of that, were you able at times to see the behavior of the defendant here in the courtroom?
I have been able to see that, correct.
Did you take that into consideration?
I have taken that into consideration, correct.
Was he able, or did he appear to be consulting with his attorneys?
Yes, he would. He was attentive, paying attention. He would consult with the attorney, specifically when they come up and do the sidebars. He puts the headphones on. He listens attentively, pays attention to the sidebars. When she would come back to the table, he would chat with her. They would talk specifically. So he's paying attention. He's interacting with her. And these are long days, lots of information, lots of stuff, and he's able to pay attention and interact. And so there aren't symptoms of that right now.
Okay. Were you able to come to an opinion as to ADHD?
I said that he has a history of ADHD as diagnosed as a child, but there aren't symptoms of it at the present time. But I can't negate that he was diagnosed with that by someone else as a child. I didn't see him back then.
Have you come to any other diagnosis of Mr. Murphy?
Yes.
And can you tell the jury about the other diagnosis?
I diagnosed him with antisocial personality disorder.
Okay. Can you tell the jury what that is, what the hallmarks of that disorder is?
Yeah. So antisocial personality disorder is an individual who basically shows little disregard for lawful behaviors, shows deceitfulness, lying, impulsivity, failure to plan, difficulties with aggressiveness, lack of remorse. They have to have had qualified for a diagnosis of conduct disorder as a child, which he would have because he had issues with fights and altercations as a child, truancy, stealing, theft issues as a child. So he did qualify for a diagnosis of conduct disorder as a child. So does qualify for antisocial personality disorder.
And conduct disorder as a child, is that, I don't know how to phrase this, but is that related in some way to a diagnosis of ASPD?
They can go hand in hand. It's not uncommon, correct. And same with substance abuse. So all of those kind of can go along together.
So I want to move on to defendant Isaiah Chance. Did you also, were you also provided materials in this case related to him and related to the same case file materials related to the investigation?
I was.
And did you assess all of the same information you were provided about Mr. Murphy, in this case, Davion Murphy, as far as it applied to this defendant? And what I'm talking about specifically are the police reports and all of the evidentiary type of information you were provided.
Yes.
And you indicated that you were provided with the deposition transcript of Dr. Hardig, and you've had an opportunity to watch her testimony here in court earlier this week.
Yes, I did.
And were you provided with documents and records that were provided to the state by Mr. Chance's attorney and their team?
Yes.
Did that include psychoeducational evaluations conducted in the public schools when he was a child?
Correct.
And diagnoses and testing that may have occurred?
Yes.
And you said you met with him on Saturday. Did you go through the same type of procedure as you did with Mr. Murphy?
I did.
How long was the meeting with Mr. Chance?
His was approximately 2 hours long.
And similar to Mr. Murphy, was his attorney, Mr. Petridis, present for that examination?
Yes, he was.
At some point in the latter part of the examination, did the defendant start having issues with cooperating?
He did. He put his head down on the table during my mental status examination, which I do at the very end, and became uncooperative. And then his attorney, and I was going to terminate the evaluation at that point. And his attorney spoke with him, and then he became cooperative and completed the evaluation.
So did you conduct the forensic, interview or evaluation?
Yes,
all right.
I did.
And did you ask him about his history as far as growing up, his educational history, other things?
Yes.
Okay. What did Mr. Chance tell you about his childhood?
Oh, he described his childhood as wonderful. He kind of glowed when he talked about it. Became very sentimental. He talked about playing board games and just he kind of glowed when he talked about his childhood.
Did he talk to you about supportive relatives that may have been around him when he was growing up?
Yes, absolutely, he did.
Okay. And you indicated, well, let me ask you this real quick. Did you also talk to him about his work history?
I did.
And did you also go through the mental status examination with him?
Yes, I did.
Can you walk us through that, how that went with Mr. Chance?
Yes, so again, we had some difficulty there because again, that was where he kind of put his head down and became upset in the end. He, again, was dressed in orange correctional attire and normal motor behavior, normal speech, gave me his date of birth. And then when I got to, can you tell me the date today? I don't know. I said, well, what month is it? He said, May. What year is it? 2026. Well, what's the date in May? I don't know. Is it the middle of May, beginning of May, end of May? I don't know. What day of the week is it? I don't know. Do you know what season it is? No. Where are you right now? Hell. And then he put his head down on the table. And so that's when we kind of, and his attorney kind of spoke to him again. And then he, participated again. He told me he was in the Falkenberg facility in Hillsborough County. He said that next month was June and he had hoped to be out. We did the 3 words, orange, tree, and car. He repeated those back to me. And at the end, he said all 3 of them. He got all 3 of them correct at the end. He was able to identify the president and 1, 2, 3, 4 of his predecessors. He was able to spell the word world correctly, forwards and backwards. He did the serial 3 subtractions, and he did like 3 or 4 calculations, and then he just counted. Once he got to 10, then he just went backwards, 9, 8, 7, 6, 5, 4, 3, 2, 1. And I said, well, what are you doing? And he said, I don't know, And then, and I said, well, what was it that I asked you to do? And he said, start at 20 and count backwards by 3, which is what the actual test is. It's not calculations. They think it's the calculations, but the actual test is, it's a concentration test. And do they remember the task at hand? So it's not actually, are they getting the math right? It's, do they remember what I asked them to do at the end of all of it? So he got that right. So he did miss the calculation when I asked him about the gas and $4 a gallon, and he had $20. He said he could buy 8 gallons of gas. Then he knew that the stomach was to digest food. He got the directions correct from Jacksonville to Miami, New York, and California. He described Martin Luther King Jr. as a powerful spokesperson for civil rights. And he got the abstract reasoning, a dog and a lion. He said they were animals. The orange and banana were fruit. A coat and a suit, he said, were clothing. And then the table and chair, he said, it's an item that is tangible. So again, a concrete answer. The correct answer again was furniture, but not as concrete as the other gentleman. And then when I asked him the proverb, what goes around comes around, he said karma's a bitch. So he got that correct. So he did fairly well as well on the mental status examination, although had some difficulties there because he was just grumpy at the end.
Okay. But you were able to complete the examination?
Yes.
So in assessing his cognitive functioning, did you note his conversational style or maybe the words that he was utilizing?
I did.
And what was significant about that to you?
He has a very advanced vocabulary. He just, in the manner that he speaks, his vocabulary, I wrote down like several things that he said because his vocabulary is very advanced. And it's not, I know, I watched the testimony yesterday, and it's not a way of saying, do you know what this word means? He uses the words appropriately in conversation. So it's very advanced. When I spoke to him about his family, a sentence he used was, my whole decorum was instilled by my granddad. I mean, that's not something that someone with borderline intellectual functioning, that's not how they talk. He said, I don't know how to articulate it when he was trying to find words to say something to me. When I talked to him about his childhood, when I brought up his childhood, and I said he started glowing. He said, "You're bringing up very sentimental topics for me. This is nostalgic." I mean, these are the words, and this is how he talked to me. So very advanced vocabulary, and he's using it appropriately when he's conversing with me. He described himself as an introvert. He used the word unorthodox. He said, "My charge is what I'm charged with is very unorthodox." He said when he was talking about his rap videos online, he said, I look at the analytical dynamic breakdown of how many views I'm getting. And, he was trying to explain the whole business of the videos and putting videos online and how you make money doing that. And he was explaining that all to me. When I asked him about his education, and I said, how did you get along with the teachers at school? And he said, well, that's difficult because there were a plethora of teachers. I had a plethora of teachers. And we talked about him and how he got along with the other kids at school. And he said, well, I had this mental capacity. And he said, so I hung around with all the different kids. And he said, but I like to hang out with the nerds because I like the differing complexity of the conversation with them. And he said at one point that he was so smart. He was sent to see a doctor at one point when he was younger. And he said, I was so smart, but my grades didn't equate with my intellectual abilities. And he said, I lacked interest, and when I lacked interest, I lacked performance, was the doctor's conclusion. So he didn't do as well in his grades because he wasn't interested. And that's what the doctor said.
Was there anything else about your conversations with him that stood out?
he was very pleasant, very engaging. I mean, he did very well until the end. And I think he just got really upset at the end and just kind of overwhelmed with it. It was more about, I think, his situation. And, you know, this was the day after he was convicted. I saw him at 9 o'clock in the morning. And it's very overwhelming.
In his work history, did Mr. Chance speak with you about things that he was passionate about doing or wanting to do?
Absolutely.
He had really strong interest in.
Yeah, absolutely. So he spoke a lot about his work history. He worked as a longshoreman in Jacksonville, and he loved that job. He wanted to be a merchant marine and go out on the water, but then when he started having children, he decided, you know, to stay as the longshoreman, and he loved that job. He worked with cars and moving cars around and doing different things there in the marina area, and he loved that job and would have liked to gone back to that job. He only left that job to go kind of do travel and get into the kind of the music industry when he did that. But he reminisced, and again, he kind of lights up when he talks about that, because it just really, you know, brought back memories from him. And yeah, he just loved that job.
That type of, I guess, behavior or desire or thought process, is that consistent with borderline intellectual functioning?
No.
And you indicated, I believe earlier, that you did receive the raw data from the testing that Dr. Hardig conducted with Mr. Chance.
I did.
You reviewed that. Dr. Harding did not prepare a report for you to review, but you did review her deposition and her testimony. Have you arrived at an opinion as to his level of cognitive functioning?
Yes, I think he has average level of functioning.
Now, as far as the issue of ADHD and Dr. Hardig's diagnosis of that, did you see evidence of that, or a diagnosis of that, I guess, by someone in the school system when he was a child?
Right. I think he was diagnosed with that as well. There's no evidence of it at the present time in my evaluation or in anything that I saw. But again, I note that somebody diagnosed him with that as a child, so I have that as by history.
So are you familiar with the manifestation of ADHD in an adult his age?
Yes.
And you're familiar with the way that that's going to show itself or manifest?
Yes.
Did you see any of that in the defendant's behavior or in any of these records?
I didn't see it in the records or in anything that I've observed.
Going back to your review of the collateral information, in this case, the police reports, law enforcement reports, and assessing the cognitive functioning of these two defendants, and looking at their actions and behavior both before the homicide occurred.
The testimony is to sway the jury from giving them the death penalty. They already are going to do life without, it's either life without parole or the death penalty at this point.
Their travel here to Tampa, their behavior throughout that evening and throughout the early morning of June 23rd, 2024, the actual commission of the murder itself, and their actions after the fact. Did you take that into account in your analysis and evaluation for both of them?
I did.
Did you see anything in that evidence for either Mr. Chance or Mr. Davion Murphy to suggest that they have borderline intellectual functioning or brain damage?
I did not.
Did you see as far as intentionality and purpose and goal-driven behavior, did you see that in that evidence?
Yes.
Okay. And was that significant to you?
Yes.
May I have a moment, Your Honor?
Yes.
Okay. Thank you, Your Honor. I'll pass the witness.
Okay, Ms. Toomey?
morning, Doctor.
Good morning.
So you spent approximately, what was it, 80 minutes with Davion Murphy?
Yes,
And that was an evaluation or interview with him that you had done over Zoom?
correct.
So you could see him from the chest up?
That's
essentially.
correct.
He had earphones on?
Yes.
Were you able to watch his manner of his gait, his walking, his movements?
No, he was seated at the table.
And let's just go back to your training for a moment. Did your training include the administration and analysis of psychological testing?
No, I'm not a psychologist. I'm a psychiatrist.
And how was it that you determined the IQ of Davion Murphy?
I did not determine the IQ of Davion Murphy.
Well, you had indicated that he was low average level of functioning, I think you said?
Correct?
What did you mean by that?
By his adaptive functioning and taking into account the IQ testing that he's had throughout his life.
So what does an IQ score of 72 mean?
Of what?
72.
That's borderline. It's a borderline IQ.
And where does that fit into the population?
It is, again, it's a borderline IQ.
What's an average IQ score?
Average is 100.
And how do you determine if someone has brain damage?
You can do neurological testing. You can do scans.
Did you do any of those things?
No, ma'am.
And do you think 80 minutes, an hour and 20 minutes without testing is enough to determine whether someone's brain is functioning?
I had the advantage of looking at the other testing that was already done and looking at all of the other information that I reviewed, correct? So that period of time was just my interview with them. That doesn't encompass all of the other things that I had access to.
Can you tell us how his work history was indicative of fast thinking?
Because he was working in fast food environments where you have to be fast thinking.
So Burger King, 4 to 6 months?
Yes, ma'am.
McDonald's?
Correct. IHOP?
IHOP is a dishwasher?
Yes, ma'am.
That you're required to have fast thinking to work as a dishwasher?
He worked there for a period of time, correct?
I don't know, did he?
That's what he told me, correct?
I don't know. Did he?
I'm saying correct, yes.
Oh, correct, okay. And then Steak and Shake?
Yes.
And you consider those to be fast thinking
Yes.
jobs? Okay. And isn't it important to figure out money calculations and how to count money, even if that's not what people are using on a daily basis today?
It can be.
You had indicated that, and correct me if I'm wrong, but you no longer believe, even though Davion Murphy was diagnosed with ADHD, that he no longer suffers from that simply because while you were watching this trial streaming online, that he was able to talk to me and discuss with me and things of that nature. He was able to concentrate, right?
It's, my opinion is not based solely on that. It's based on my years of training, expertise, and observations of everything and all of the information that I reviewed.
And the total amount of time that you spent with Davion Murphy was 1 hour and 20 minutes, correct?
Overall, go ahead.
That's the amount of time that I interviewed him, but I've watched numerous different videos. I've watched his interviews with the police. I've watched hours and hours and hours of this trial.
Did you meet with him on a one-on-one setting in person at all?
No, ma'am, I met with him on Zoom as we discussed.
So are you discrediting? Are you saying that Dr. Eisenstein is incorrect in his findings, even though he met with Davion Murphy in person on 7 different occasions throughout multiple months for over 20 hours?
No, ma'am, I said that I disagreed with him.
You disagree with him?
Correct. And I didn't see where he delineated the symptoms supporting a diagnosis of ADHD. I never saw that in his report nor heard him testify to that.
All right, let's talk about your mental status examination that you
Yes, ma'am.
that you did. Isn't it part of a mental status examination to look at their appearance and their behavior, hygiene, grooming, posture, their physical appearance?
Correct.
Were you able to determine whether or not Mr. Davion Murphy had anything wrong with his hygiene?
No.
Okay. What about his posture?
Right. He sat appropriately in the chair throughout my evaluation.
How were you able to determine whether he sat appropriately in his chair during your evaluation if you were on Zoom?
From what I could see, you can see someone sitting in a chair.
And you weren't able by Zoom to see any of his motor activities while you were questioning him, right?
He did not appear to be fidgeting, wiggling. He appeared to be sitting appropriately in the chair throughout the
Well, because you
evaluation.
saw him chest up, right?
Right, but he wasn't wiggling or jiggling. There wasn't moving around.
Do you know whether or not he's been jiggling or shaking his leg this entire time during this entire trial?
I can't see him as I'm testifying here today because of the way that the desk is situated, so I can't testify to that.
Okay, so you can't testify as to whether or not his motor activity was anxious or something else.
Not today, I can't, no ma'am, because I can't see him because of the way that the judge's desk is set up.
And because you couldn't see him that way on Zoom either, right?
Correct, but he was not wiggling in the camera.
Well, his leg could be shaking over there, but not shaking the desk.
And asked and answered. Next question.
And you said that he knows the alphabet because he could spell the word world.
He spelled the word world correctly forwards and backwards. Also on the testing that Dr. Eisenstein did, he tested as reading on the 7.6 grade level. So you can't read at a 7.6 grade level without knowing the alphabet.
7.6 grade level.
Yes, ma'am.
And Mr. Davion Murphy is how old?
29.
So he reads at a 7.
Objection.
Overall, go ahead. You can answer.
That was on the testing, yes.
Let's go back to, you had indicated that the state had provided you videos, some cell phone extractions, autopsy photos, police reports. How many hours did you dedicate to reviewing the state's discovery in this case?
I have not had time to sit down and add it up.
Was it longer than you spent with my client, Davion Murphy?
Absolutely.
Absolutely. Okay. And what is the percentage of work that you do for the state?
The work that I do for the state, I'm more frequently hired by the state than by the defense, but I am hired by both.
And what's the percentage breakdown?
It's probably 65, 35, 65% for the state and 35% for the defense.
And I think you had indicated that you are part of the 3 psychiatrists that are on the board for the governor when it comes time to execute someone.
If there's a question, if there's a mental health question, yes, I have been appointed to that board.
Have you ever recommended have you ever recommended that someone not be executed?
Objection,
Overruled. Go ahead.
I believe that we have, yes.
How many times?
Objection, relevance.
Sustained.
You said we have. Who's we?
The 3-member board.
Okay, because there's 3 and you need 2, right?
No,
No?
we all write one report.
And then what happens?
It goes back to the governor.
So then who ultimately decides?
The governor.
And how long have you been sitting on that board?
Probably 20 years. I've been appointed over the years.
The American University of the Caribbean School of Medicine. Is
Yes,
that
ma'am.
in the US?
No, it was in the United States when I went to it. Actually, I attended it. It was in Texas.
Would you agree with me that the Texas Function Living Scale is a valid test to determine one's functioning abilities?
Yes, it's designed to test functioning abilities for individuals with dementia.
No, that's not true. It's not solely for
Objection,
dementia.
argument
Yeah.
is-
So ask a question. Please don't argue with the witness.
It's not only for dementia, it's for other things, is it not?
But that's what it's designed for, just like the MOCA is designed for individuals with dementia. Correct.
Now, you had indicated that, correct me if I'm wrong, that Davion Murphy diagnosed him with adjustment disorder.
Correct.
And in order to get a diagnosis of adjustment disorder, one's development of emotional or behavioral symptoms in response to an identifiable stressor has occurred. And you've identified that stressor as him facing these charges and being incarcerated, right?
Correct.
That's the stressor. But isn't it true that that person's response to that stressor must be out of proportion to the severity of it?
Yes, but he's been diagnosed with symptoms and started on medications.
So how are you, I mean, if somebody's stressed because they're facing the death penalty, right?
Yes,
His stress is not out of the norm, correct?
correct.
But you still consider that that he suffers from, or you've diagnosed him with adjustment disorder.
Yes, because I think it's in relation to that stressor, absolutely. It's a significant stressor, I agree.
Well, how is his behavior out of proportion to that stress?
I don't think his behavior is out of proportion to that stress. I think he has emotional, issues. I think it's in response to that stressor.
But it's not out of character.
Correct.
Right.
And if you read in the beginning of the DSM, it's not designed to be used in a cookbook fashion, so it's not designed to be used by people who aren't trained to use it. So you can't take every word like you're taking it.
Well, I mean, that's
And
what it
apply
says,
it.
though.
Hmm?
That's what the DSM-5
Yeah, but it also
says.
says it's not designed to be used in a cookbook fashion by people who aren't trained.
I'm not claiming to be trained.
Well,
You
that's
are,
fine.
right?
Right, and
You're
so I'm
trained.
using it
Okay.
and not in a cookbook fashion. I believe he has
So-
adjustment disorder.
So tell me how Davion Murphy is acting out of proportion to the stress of being potentially executed by the state of Florida?
Objection, Your Honor. Asked and answered and argumentative at this point.
You can answer one more time. Go ahead.
I don't believe it's out of proportion. I think it's a significant stressor. And I think that he has symptoms in relation to that significant stressor, and he's being treated for them. And so that's the most appropriate diagnosis according to the DSM-5 TR. And again, there's a section in the beginning of the book specifically relating to forensics, and it says specifically it's not to be designed to be used in a cookbook fashion. You have to be able to apply it using experience and training.
All right, and then what was your other diagnosis, doctor?
I gave him antisocial personality disorder and then the substance use disorders.
And what is the criterion or criteria for one to meet that diagnosis?
Which diagnosis?
The antisocial personality.
Right. So he has to have 3 of the 7 criteria. Disregard for lawful behaviors, deceitfulness, lying, impulsivity, aggressiveness, lack of remorse. Those are all things that are in his history. He has to have had conduct disorder, met the criteria for conduct disorder as a youth, which he did, having met over 3 of the 15 criteria for that disorder.
Was he diagnosed with conduct disorder when he was young?
No, but he met the criteria for it if you go through his history.
Okay, but he wasn't diagnosed with that. Right?
No, but he met the criteria for it when you go through his school records and his history.
And part of this criteria is that the person has to repeatedly lie, right? Part of that is being deceitful and repeatedly being deceitful, being lying all the time.
Correct.
Conning others for personal profit, using aliases.
That can be some of them, yes.
Do you know of any times where Davion Murphy has used an alias or has conned others for profit?
No, and I don't believe that I use those as examples.
And then impulsivity is one of the criteria, right?
Correct.
Or failure to plan?
Failure to plan ahead, correct.
Failure to plan ahead. So you think that this Davion Murphy's involvement in this crime was impulsive and he failed to plan?
No, not at all. So examples that the DSM uses with regards to failure to plan ahead is with regards to like employment, where you're going to live, kind of adult behaviors and kind of planning out your life, buying a house, how you kind of live through your life and planning your life ahead. So not getting into through school. So those are the behaviors that it identifies as planning ahead.
But you also put a lot of time and effort in going through the state's police reports and videos and things of that nature, right?
Correct.
Right. And if someone is diagnosed with that personality, they're impulsive and they don't plan, right?
No, that's not true. That's not true.
So that's not part of the diagnosis?
It's impulsivity and failure to plan ahead with regards to their life and not with regards to one specific crime or incident. I think you're trying to kind of narrow it down to the instant offense as opposed to his life in general.
So then his life in general has been impulsive and he's failed to plan?
Yeah, and jumping around from job to job. There are things in his life, yes, which are evident, and with regards to lawful behaviors and disrespect for lawful behaviors and getting in trouble, and yes.
Did you know that Davion's father was charged with murder and arrested, and he's incarcerated in prison for the rest of his life when Davion was just 12 years old?
Objection, relevance.
Overruled. You can answer if you know.
Correct. I believe he told me his father went to prison when he was 11, actually.
Would you consider that to be a traumatic event for a child?
It could be, yes.
It could be.
Yes.
What about the fact that his youngest brother is also incarcerated?
Judge, objection,
Would that
relevance.
also be,
Overruled. You can answer. Go ahead.
would that also be traumatic?
It could be.
What about being shot in a drive-by shooting? Would that be traumatic?
Objection, facts not evidence.
Overruled. You can answer.
Yes.
That would be a traumatic event.
And maybe, yes.
Watching or learning about your friends being shot and killed, family members being shot and killed, that was would also be traumatic, right?
Yes, they can be.
And how much are you charging the state per hour?
Meridian does the billing. I believe they charge $400 an hour for my time.
And you don't have a breakdown of how much you spent on this case, or have you billed the state for your
No,
time yet?
there have been no bills sent out, correct?
Okay, thank you.
Okay, Mr. Petridis.
Morning, Doctor.
Good morning.
Talk to you about Mr. Chance.
Yes.
So you met with Mr. Chance probably what, a little less than 2 hours, did you say?
Yes, about 2 hours, correct.
And about a little over an hour of that was you getting the background that you talked about, correct?
Correct.
Now the testing, and I think you kind of talked about this, but this was not, what should not be considered IQ testing, what you did, correct?
Correct.
Do you have any training in diagnosing intellectual disability?
Yes. I don't do IQ testing, but yes, I've done that.
All right. So in your opinion is you disagree with Dr. Hardig's opinions?
Correct.
So is it fair to say that you also disagree with the opinions of the testing he had in school on the 3 separate occasions?
No, I don't disagree with the testing. I don't disagree with the testing.
My apologies, poorly worded question. You disagree with the results of the testing from school?
No, results are results. I don't disagree with results of testing.
But you disagree with Dr. Hardig's results of testing?
I disagree. I have a differing opinion than her opinion with regards to diagnosis. I don't disagree with her test results.
Right.
Results are results.
Would you agree that someone with a well below average intelligence could be able to do hands-on repetitive jobs?
Yes.
And would you agree that symptoms of ADHD could be less apparent later in life when you're not sitting in school for having to pay attention to different teachers for 6 to 8 hours?
They may be, yes.
And would you agree that the inability to hold a job for a long period of time would be a symptom of ADHD?
I'm sorry, could you ask me that again?
Sorry. Would you agree that the inability to stay at a job for a long period of time would be a symptom of ADHD, or could be at least?
It may be.
And would you agree that people with borderline intellectual disability can have jobs and obtain driver's license and things like that, simple things?
Yes.
Now, you talked about Mr. Chance becoming overwhelmed at some point during the interview.
Yes.
Was this around the time that you talked about his children to him?
He did not want to talk about his children, and I left that alone. So that was another instance. That was a separate instance. Yes, he did become very emotional talking about his children. And so I did not go into as much depth about his children as I normally would, getting their names and ages and that. I did leave that alone out of respect for him because that was yes, he became emotional about that. Correct.
I think you said this, but just to clarify, you would agree that him becoming overwhelmed had a lot to do with the recency of the verdict in this case.
Correct. It was the night before. Yes.
Right. And I think you meant this more in a clinical sense of his being uncooperative. He wasn't aggressive. He just was overwhelmed.
Correct. Yes, absolutely. I felt it was very emotional. Yes. Yeah. It was very raw emotion. Yes.
And he talked about his work history with you.
Yes, he did.
He didn't hold any job for very long. Would you agree?
He, I thought he did with the, longshoreman. Hang on. I thought he did at the longshoreman, but I don't recall how long it was.
Okay. You didn't, and I think we know this, but you didn't test his math, his reading, his perceptual reading, correct?
Correct, except for with regards to, as I said, in the mental status examination as we went through that. Correct.
Did you leave the possibility out for what we call reverse malingering, someone trying to appear smarter than they are? Could that be one of the reasons for using bigger words?
No, as I said, I think, certainly I consider all of that, but he was using the words appropriately in conversation. The way that you and I are conversing, he was using that vocabulary appropriately throughout the interview. It wasn't kind of interjected here and there in that manner to try to impress me or, do you know what this word means? One time he said, do you know what the word ostentatious means? And I said, yes. And he said, that's me. That's how I describe myself. I love myself. But he only did that one time. Other than that, the words were normally interspersed in his conversation. And I've seen writings from him with the same vocabulary interspersed in the writings to the court.
You talked about his behavior during the trial, but I think you would agree that you don't know none of us know what's going on in his head during the trial, what he's thinking about, what he's not thinking about.
Correct.
All right. And you don't know, obviously, the conversations that myself or any other team are having with him during the trial, that you see us talking, you don't know what we're talking about.
Correct.
Okay. So would you agree you can't say that he's fully paying attention, you just believe it appears that way?
Correct.
Judge, may I have a moment?
Yes. Okay, redirect.
Doctor, this is specifically as the defendant Chance. So when you conducted your interview, when you met with him at the Hillsborough County Jail through the Zoom, I mean,
yes,
this is less than 24 hours after he has been convicted of capital murder, first-degree murder, right?
Correct.
And the jail is only providing a 3-hour window for your evaluation. Is that right?
That's correct.
Same with Mr. Murphy.
That's correct.
And that's by their rules and regulations, right?
That's correct.
And by law, you don't have access to the defendant before conviction, right?
That's correct.
And
overall, go ahead.
And was, as far as you know, was this trial set to begin or resume on Monday?
That's correct.
Now, you were talking about Mr. Chance and his conversations and the vocabulary. Was this something that was occurring, him using those words and those different vocabulary words that stood out to you in the middle of conversation as he was speaking, just fluidly speaking?
Yes, that's correct. Yes. So I had to go back through my notes and take those sentences out of his book, of his, interview with me, because it was fluently interspersed throughout the interview.
And it looked like words that he was comfortable using?
Absolutely. They were appropriately used in the correct, in his conversation. Correct.
And they were appropriate to the context in which he was using them?
Yes, that's correct.
Now, you mentioned a writing that he had written to the court, and
Yes.
you've reviewed that?
Yes, that's correct.
Do you recall him using the term hypothetical supposition
Yes,
and arbitrary inconspicuous theories?
yes.
substantiating action of surreptitious immorality,
Yes.
extrinsic information, do you remember that wording?
Correct.
With no on its face corroboration,
Correct.
no prima facie cooperation of corroboration.
Yes.
And again, do you recall him using the term a plethora or
Yes.
a plethora,
Plethora.
of public figures?
Yes.
So it wasn't just in your conversation with him, it was in a separate writing before you ever had contact with him.
Correct.
Now, when you're determining intellectual ability, you're not testing like these psychologists did. You're not administering IQ testing. That's not what you did here.
Correct.
But
So
you- go
I
ahead.
utilize psychologists IQ testing, but then do the adaptive functioning portion of it.
Okay. And you've been doing and conducting these types of evaluations for decades, right?
Correct.
And probably thousands, if not tens of thousands of people.
Yes, correct.
So you have a lot of training and experience.
Yes, sir.
And are you trained in both your residency and fellowships in psychiatry and forensic psychiatry?
That's correct.
Do you meet with patients during that time period?
Yes.
Is that what you were doing at the hospital associated with Yale University?
Yes, that's correct.
And you were asked, this is for both these defendants, because you were asked by both these attorneys about observations and ADHD. You are trained and familiar with manifestations in adults who have ADHD?
Yes, sir.
And is it something that would stand out to you? You would see it?
Yes.
And you haven't seen that in these defendants? Well, I can rephrase. Have you seen it in these defendants?
I haven't noticed it in anything that I have reviewed or been able to observe. Correct.
Would that also involve video and other evidence from the case itself, the investigation?
Correct.
I want to talk to you real quick about Davion Murphy's employment history. Counsel had asked you about him being a dishwasher. Do you recall that being at Cracker Barrel?
Correct.
And he worked there for approximately 8 months?
Correct.
And he would have been at Burger King for about 6 months?
That's right.
Now, at International House of Pancakes and Steak and Shake, which he worked at for 6 months at Steak and Shake, do you recall that?
Yes.
At those two employments, he was working as a short order cook, correct?
Correct.
Do you believe, or do you have experience being around short order cooks and the demands put on them in restaurants like that?
I've eaten in them.
Yeah.
Yes.
And would you agree there's a timed element and a time urgency?
Yes.
And they have to perform tasks under a time, or basically a time limit?
I could not.
Overruled. Go ahead.
I could not do that job for a significant period of time. Yeah, it's a very stressful situation. If you've been there and you've watched them and they're yelling at them and they're trying to juggle, multiple orders at a time and trying to get all of the food out at one time. I mean, we've all cooked for Thanksgiving and trying to get kind of all the food ready at one time and get it out at one time. And, that's what they're doing. They're trying to juggle multiple orders of food and get it all out at one time, not only for one table, but for multiple tables. So it's a very stressful job. Yes.
You work for Meridian, correct? You said?
Correct.
And that is a corporation or a company?
It's a nonprofit.
A nonprofit.
Correct.
Sorry. And that nonprofit bills us, the state of Florida, for your work in this case?
Yes.
In psychiatry and clinical psychiatry, do you have to, or have you come across people who have dementia or Alzheimer's?
Yes.
And you indicated that the Texas Functional Living Scale is designed in some way for that?
Yeah, that was its initial function. Same with the MoCA, correct.
Now, I believe you were questioned by counsel about the planning or lack of impulsivity in the facts of this case itself.
Yes, sir.
Do you recall that?
Yes.
All right. Because that is one of the several diagnostic criteria for antisocial personality disorder.
Correct.
All right. And there's a long list of those. Did you find all of those to exist in Mr. Murphy's case?
The criteria for antisocial?
Yes, ma'am.
No.
Okay. But as far as that goes, and you indicated what it's described as, that's going to managing one's life in a long-term plan.
Correct.
Now, in this case, did you see evidence of long-term planning, or at least weeks of planning? What appeared to be
With regards to this case,
to
yes.
the murder? Yes.
Yes, absolutely.
Did you see intentional, purposeful action that occurred during the actual murder itself?
Overruled, go ahead.
Yes.
Was there anything about the homicide in this case, from what you saw, that had any indicia of impulsiveness?
No.
Does that, in your mind, eliminate or in any way erode your diagnosis of antisocial personality disorder?
No.
I have nothing else.
Okay, very good. May this witness be excused?
Yeah, sure.
Okay, thank you. You're
Thank
free to
you,
go.
Your Honor.
All right, approach the bench real quick. So it's about 11:45. The next witness will be appearing at 1:00 via Zoom. So we're going to go ahead and take our lunch recess now. So if you all can please return at 1:00. And then I believe that will be the state's final witness before you rest and rebuttal, correct?
Yes, Your Honor.
Okay. All right, very good. See you all back here at 1:00.
All rise.
bailiff is handing out to you all the final copy of the jury instructions and the verdict forms for each of your clients. Okay, our jurors back? Okay. Let me see. And it's Glickstein, correct? Yes. Yep, he's there.
Oh, he is?
Yep. I know. And the doctor that was reading the scans, he was using a lot of, I couldn't understand. I hope Ashley. I know. Okay, very good. All right, well, I'm going to go ahead and let the witness in to the Zoom. Hello. Hi, Dr. Glickstein. Can you hear me?
Yes, I can.
Okay, very good. We're about ready to get going. So let's go ahead and bring in our jury. Which? Okay. What's up?
Yes. Yeah. So since Dr. Glickstein is appearing by Zoom, I'm going.
Okay, we ready to go? Okay. You all make a decision yet about the alternate situation? No? Okay.
I don't have an issue with only having one. I have concerns about letting them.
Okay, well then we'll just go with the next person up would be the individual that I discussed already. So I'll break the news to him. Okay, no, I won't.
And then while we're waiting on the jury instructions, they look good. But that page 20 is to the court, their comments for the court. I don't think so.
Oh, yeah. Just toss that.
Okay.
And I'm missing one of my mitigators.
Which one?
The defendant has a history of physical and emotional abuse as a child consistent.
Oh, okay. I will make that change and then I'll just give you an insert. I think when I sent them to my JA, I made the change here, but it didn't make it to her copy. So I will make that change. All right, you ready to go?
Yes, sir.
Okay, let's bring them in.
All right.
Okay, very good. State, call your next witness.
State would call Dr. Mark Lickstein.
Okay, sir, if you please raise your right hand to be sworn.
Can you raise your right hand?
Yes,
Do you solemnly swear or affirm that the testimony you're about to give in this class will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
May it please the court.
You may proceed.
Good afternoon.
Good afternoon.
Please state your name.
Dr. Mark Lickstein.
And sir, how are you employed?
I'm a diagnostic radiologist.
And do you maintain your own practice or do you work for some other facility?
I have worked for the University of Pennsylvania in the past.
Okay. And in addition to clinical work, do you also provide forensic and consultation services in the legal realm?
Yes.
And for how long have you done that?
Over 30 years.
Can you tell the jurors your educational background, doctor?
Yes, I went to undergraduate at Brandeis University outside of Boston. Following graduation, I went to medical school at Yale University School of Medicine in New Haven. I then did a internship and residency in internal medicine at Yale New Haven Hospital. And I then went into radiology, doing a radiology residency and following that with a radiology fellowship at the University of Pennsylvania.
Can you tell the jurors your work history in the area of radiology, diagnostic radiology, and internal medicine?
Yes, I've been employed from 1987 through this year. I worked for about 28 years with a large group in Connecticut. We had a large teaching hospital as well as multiple other peripheral hospitals and outpatient centers. Following that, I moved to Florida in 2014 approximately. And I had a few positions down here before I started working with the University of Pennsylvania about 6 years ago.
Do you maintain hospital privileges at any facility?
Not currently, no.
Have you previously held hospital privileges?
Yes, at more than a dozen hospitals.
And did that include a hospital that is associated with the University of Pennsylvania?
Yes.
Can you, well, let me ask you this. Do you hold any board certifications, doctor?
Yes, I'm board certified in internal medicine and radiology.
And what academy or society awards that board certification?
It would be the American Board of Internal Medicine or the American Board of Radiology.
Doctor, do you belong to any societies or other regulatory agencies or bodies in the area of radiology?
Yes, I've been involved with a variety of societies in the past. Currently, I only maintain involvement with the Radiology Society of North America, American Röntgen Ray Society, but in the past I've been members of a variety of other societies. I've served as a consultant for the health department in the state of Connecticut. I served on several advisory panels for Blue Cross Blue Shield, and that's most of it as I can think of off the top of my head right now.
Okay. And how long have you been practicing in the area of radiology, doctor, in total?
About 40 years now.
40 years, okay. Have you ever testified previously as an expert in the area of radiology or diagnostic radiology?
Yes.
How many times?
More than 100.
And in what jurisdictions, doctor?
Well, I've testified in numerous cases in Florida. I've testified in cases from many other states. I don't know if you want me to list them, but there's probably over 20 different states that I've viewed cases from.
Okay. And doctor, in your capacity over the last, I think you said 30 years doing consulting work in the legal area, have you consulted on both civil and criminal cases?
Yes.
And in criminal cases, have you consulted and worked on cases for both the prosecution and the defense?
No, I only have done cases for the prosecution.
Okay. And in the civil realm, have you worked in both plaintiff and defense sides of the civil practice?
Yes.
Now, this case involves testimony in a penalty phase of a capital murder case. Have you ever testified in a setting like this before?
Yes.
Approximately how many times?
Just one, as far as I know, maybe two. I'm not sure.
And are you licensed to practice law here in the state, or practice medicine, excuse me, here in the state of Florida?
Yes.
Okay. Can you explain to the jurors what the medical field of radiology deals with?
Sure. Radiologist is a physician. I'm an MD, and a radiologist specializes in medical imaging. Before you get to be a radiologist, you have to do some general medicine training, but a radiologist is the one that reviews and interprets all of the imaging that comes from hospitals and imaging centers. We review the cases, issue reports to the referring clinicians, and serve as a consultant to them.
And when you're talking about imaging, what type of technology are you talking about?
Well, imaging can be in the form of X-rays, it can be CAT scans, MRIs, nuclear medicine studies, PET scans, ultrasound. Those are all the modalities.
And as to MRI technology, can you explain to the jurors what that involves?
Sure. Well, an MRI is a machine, and many of you are probably familiar with that, but it basically looks like a large cylinder, and the patient is placed into that, and with the use of very high magnetic fields, signals can be detected by the computer system, and those can be reconfigured and reinterpreted into actual images. So it uses a different technology than X-rays. It uses the high magnetic fields.
And X-rays use some form of radiation?
Correct.
Is that correct? Okay. And do you have training and education and experience with MRIs?
Yes.
And is there a type of MRI, a DTI MRI?
Yes.
What is a DTI MRI?
Well, DTI imaging is a type of MRI where basically fluid that travels in the neural structures, which are called neurons or the axons of, or actually neurons. They are contained by a sheath that separates them from the rest of the brain parenchyma. And the DTI imaging will evaluate the flow of fluid in these neural structures. And what it can do is ostensibly identify various tracts or connections between the brain. And you can see those and color code them for different directionality of flow.
So when you said earlier that as a radiologist or a diagnostic radiologist, if a physician is referring a patient, the patient is prescribed to have certain imaging such as an MRI, that image will come to you to conduct an evaluation of that image and give your opinions on it or your impressions?
Correct.
And then you would consult with the treating physician?
Correct.
Would that be true for a neurologist who has a patient who sends the patient to have imaging done?
Yes, it would be the same procedure, I would imagine. Every case doesn't involve a direct consult, of course. Usually there's just a report that's issued and delivered to the clinician, and then if there are any other issues, you would talk about it further.
Okay. So the report, when you prepare a report, does that have some type of a signature or name? Not your name, I mean the name of the type of report that you're preparing.
Yes, it would.
And what is that normally referred to when a report is prepared by a radiologist?
Just a radiology report.
Radiology report, okay. So, but you're looking at images that have been submitted to you by whatever, I guess, laboratory that prepared those, and then you're evaluating them and preparing a report to your findings?
Yes.
Is that accurate? Okay. MRI, DTI, and MRI images, is that something that you have dealt with over the course of your career?
I have dealt with it, yes.
How long has that technology been utilized in medicine, especially obviously in radiology?
It hasn't been around for that long. I couldn't give you I mean, there have been, early studies where it was more experimental and really not clinical. So those may have happened sometime earlier in the past. But I would say, in my experience anyway, I've probably seen it over the past 5 years or so. I haven't really come in contact with it before that.
With MRI technology or specifically DTI?
DTI. MRI, I was thoroughly trained in MRI. I was when I started my practice in Connecticut, I was the first physician in the state with actual fellowship training in MRI, and I've been doing MRI since 1987.
How many times do you believe that you may have conducted a review of MRI imaging and prepared a report or acted as a consultant?
I mean, I couldn't even put a number on it. Thousands.
And so I would assume with those would involve looking at actual MRI imaging going back into your education. That would be probably in the tens or hundreds of thousands of images?
Yes.
So DTI, that form of MRI, has only been around for the last less than a decade, I guess, from what you're saying.
Don't hold me to that number, but I think, as I said, in my experience, I have not seen it used prior to that.
Now, in this case, were you retained by the state of Florida late last week to consult, in this case, in a legal capacity or medical legal capacity?
Yes.
And when you were retained, did you provide a fee schedule to the state of Florida?
Yes.
And that is your personal fee schedule for your work or services?
Correct.
And could you advise the jury, please, of what you are charging the state of Florida for your testimony in this case, as far as first of all, your work on the case?
Yeah, I would bill $3,000 for my testimony today.
For your testimony today, okay. Do you know what the total amount you will be billing in this case? With your review and testimony?
Not off the top of my head, I would say, I don't know. I'd have to sit down.
Was there, in the fee schedule, was there a $2,000, like an initial fee to review materials, possibly?
No, this would be, well, yes, there is that fee for reviewing the materials, yes.
Okay. And then your testimony today, you said would be $3,000 approximately?
Yes.
Okay. Have you been provided with a series of slides that are in a PowerPoint presentation?
Yes.
And do you have that presentation, and are you capable where you're at by Zoom to publish it so that the jury could see it while you're testifying?
Yes, I can put that up on my screen if you give me a minute to just get my orientation here. Let's see. Just bear with me for 1 minute.
Yes, sir. That's fine, doctor.
Sorry. Okay, I can show that to you now. Let me just share my screen. Oh, you have to send me something to allow me to share.
We may need a technical.
Where's Richie?
I want a nice invitation.
Okay. Let me see here. Oh, wait.
Oh, let me see here. I
Here
just
it
sent
is,
a
here it
request. I think you.
Good.
There we go.
Woo. Okay.
I think that'll work.
Yes.
Oh. Okay.
You should, I think I enabled it.
All right. So, can you see my screen now?
Yes.
Yes.
Okay.
Very
Great.
And doctor, is there a way, you know this better than I do, but is there a way while this is up here for you to use your cursor to point to anything on that, if possible?
Yes.
Oh,
Can you
good.
see my? Yeah.
Yes, we can see it, I think. Now, the first series of images here are very colorized images. Do you recognize those type of images?
Yes, it's a PET scan.
Okay. And is that a technology that you work with regularly?
I do not personally, no.
Okay. As you go towards the bottom of these slides into the higher number of slides, do you come upon some black and white images that are double, an image that sits on the left and an image that sits on the right? Looks like it starts at slide 13.
Yes.
Okay.
That's up here now.
All right. Do you recognize those images?
Yes, those are scans from an MRI towards the top of the head.
Okay. So could you orient the jury as far as if we're looking at the brain, what direction we would be looking from when we're looking at these scans?
Sure. Well, in radiology, everything gets kind of turned around. So the left side of your screen of the image is actually the right side of the patient. So this is the front, this is the back, This is the left, and this is the right.
And these images, if a person was to look at the person's head, would these be images where the camera would basically have to be mounted somewhere within like the neck or somewhere within the body to take that? If you understand what I'm saying. I know that's not the way the MRI is taken, but.
Sure. Yeah, no, I understand. Yeah, what happens with doing a brain scan is you have essentially a smaller cylinder into which your head can fit. And it's like a little cage, if you will. And that serves as a receiver for the MRI signals. And that's how they're obtained.
Okay. What are these images showing?
Well, there's nothing abnormal on the image, first of all. It's a normal scan. And what we see here, this is the brain itself right here.
Okay.
So this stuff here is really is just the soft tissue and the skull bone. And this part of it here around the very periphery is just the subcutaneous fat. And that's all that is. Now, what we see in the image of the brain here is there are two different main colors that you can see. There's a whiter area over here, and there's some darker gray in the middle. Those are referred to as the gray matter and the white matter, respectively. And these, like for example, this area here would be these certain areas in the brain control certain functions. So like this would be the motor cortex over here where your arm and leg movements are controlled. So we can identify different regions, and we can look at and we have very good tissue contrast where you can see the difference between the gray and the white matter, as opposed to a CT, for example, where you really don't see that quite as well.
And the image on the, both images, why are they different? Are they different perspectives, or are they a different type of MRI?
Well, they're all MRIs. MRIs are done routinely using, you actually don't take just one set of images with an MRI, you take multiple sets. And each of these has different settings on it. So it's sort of like having a camera and changing the lenses on it. You basically can look at different things with the MRI, and the colorization, the contrast, many things about the scan are different. These are actually this is actually the same patient at exactly the same level, but just because the MRI was obtained using different settings, you get a different appearance of it.
Okay. Can we move to slide 14?
Yes.
All right. And this is going to be at a slightly different level of the brain than the previous slides?
Yes, it's a few centimeters, a couple of inches down from the top of the head towards the sort of going towards the chin.
Okay. But these images are reflecting basically the same part of the anatomy, the same part of the head?
Yes.
Okay. And in the image on the right, again, concentrating on the material in the middle, the brain, there's this line going down the middle of those two halves. What is that?
This?
Yes, sir.
Yeah, that is called the falx, F-A-L-X. It is just simply a fibrous structure that separates the two hemispheres of the brain.
And is that normal in appearance?
Yes.
Is there anything in that image of the brain that is abnormal?
No.
Does the brain appear to be normal?
Yes.
Do you see any evidence of scar tissue or brain damage?
No.
And looking at the image on the left, Same questions. Do you see any evidence of scar tissue or brain damage?
No.
And if we can move to the next slide, 15. Looking at the image on the right, now we're at a slightly different level of the brain. Is that correct?
Yes.
All right. And in this image, same question. Do you see any evidence of scar tissue or brain damage?
No.
Any evidence of any kind of impairment of any kind to the brain?
No.
In the image on the right, if you look at that dividing line in the middle, the fox, and you go to the right as you look at the image, and slightly up, if you can put your cursor just slightly up, there is a shadowy, like white in that gray area, kind of to the right there where you have your cursor. Is that anything that would reflect scar tissue?
No, that's normal. That's just all normal.
Can we move to the next slide, slide 16, Doctor? Now we're starting to see a different appearance to the brain here, different appearance to the slides. Can you identify the anatomy that's now reflecting in the middle of the brain?
Right. So we're a little bit lower down in the brain here, probably through about the middle of the brain. And we have these two structures here, kind of like a C shape, reverse C shape. And these are called the cerebral ventricles. Those are fluid-filled spaces that contain cerebrospinal fluid. And cerebrospinal fluid covers the brain and the spinal cord, and it serves as an insulator. And it is formed in the brain, in the tissues of the brain, actually not in the actual brain substance, but in some of the tissues around it. And it's secreted into the ventricles, and it flows through the rest of the central nervous system.
Do you see anything in that image on the right or the image on the left that demonstrates or shows you any type of scar tissue or brain damage?
No, the studies are normal.
Can you move to the next slide, 17? And now we see a significantly different look here, or a different part of the anatomy. What are we looking at here? What is being shown in these MRIs?
So here is a slice that is through the lower portion of the brain. We're almost out of the brain here. And what you can see, this is the front, as I said, this is the face. This is actually part of the nose here. The two eyes are right there. And what we see in the brain here is part of this structure is called, these are called the temporal lobes. Those are one of the portions of the brain. And then in the back of the brain and lower down, there is this other structure, which is called the cerebellum. And we can see that there. And just in front of the cerebellum is what's called the brainstem. And these are the structures that are depicted here. And again, they are all normal.
You don't see any evidence of brain damage or any abnormality in those slides?
No.
If you could go to the image on the left and bring the cursor up to the interior or top portion of the right, nope, it would be to your left, the right temporal lobe. That would be the right temporal lobe that's reflected on the left in the image, correct?
Yes.
Okay. Now, if you go towards the top of the image, there are two black dots, those two right there.
Yeah.
What are those?
Those are just cortical veins.
And what are cortical veins?
Everybody has them. They're just, the veins basically return the arterial blood flows through the body, and then it flows into the veins. And as in the rest of the body, when blood flows into the brain, it has to go somewhere, so it leaves the brain through the veins.
In these images, the axonal, is there a thing known as an axonal flow? Is that an event or a thing?
Axonal flow would not be depicted on this study.
Okay. So these studies would not reveal a disruption in the axonal flow?
No, not based on this MRI image that you've asked me about, no.
And I think we're at 17. Is there a slide below 18?
No, that's
Okay.
18 is the last one.
All right. If we can go to the very top of the slides, to the number 1 and 2 slide. I know these are PET.
Yes.
If you could click on that. I just had a question for you, and I'm not going to ask you to interpret anyway this PET, but on the left-hand side of the image at about the 9 o'clock position, there is a red dot or like an orange circle.
Yes.
And my question to you is, you would agree this is an image of the brain. You can say that.
Oh, yeah.
Yeah.
Sure. Yeah.
Well, let me see what the question is first.
Right. You do have some familiarity with PET, correct? PET scans?
Yes.
Generally, you know what they are and something about the technology?
Yes, I've reviewed PET scans, and I do it in when I have need to read a case, for example, and compare it to a previous study. I will look at the PET scans.
That area that I was pointing out to you at the 9 o'clock, if that small area of orange, if that was the only normally performing part of the brain and the whole remainder of the brain was brain damaged, what effect would that have on the person?
I really can't answer that question. It depends on the type of damage. It depends on so many different things. I just couldn't answer a question like that.
Okay, good enough. We may have one moment, Your Honor.
Yes.
I'll tell you the witness, Your Honor.
Okay. Jimmy?
Good afternoon, doctor.
Hello.
Hello.
Good afternoon.
I think we've met before. You probably don't remember me, but I do remember you.
I do remember you, as a matter of fact.
Okay, very well. So you're a diagnostic radiologist, correct?
Yes.
And I think you had testified that the MRI, let me get my bearings here, the MRI DTI is fairly new in the diagnostic world.
Correct.
And you had indicated that it's been around for approximately, I think, 5 years, you said?
Well, again, I don't know the actual answer to that, but as I said, in my experience, yes.
Okay. And you're not a neurologist, right?
Correct.
But neurologists are able to read, I guess depending on their training and their experience, are able to read scans, images, things of that nature, right?
Well, they do read them. Honestly, I don't know whether they issue reports or bill for their scans the way radiologists do, but yes, they look at the scans, of course.
And usually the neurologist takes on a more hands-on position than a radiologist with the patient.
Sure, it's an entirely different role.
And so you act as more of a consultant to whomever you would be reading the scans for, right?
I didn't quite catch that. Sorry, could you?
Sure, I apologize.
Sure.
You consult with other physicians, correct?
Yes.
Have you had any training on how to read MRI, DTI images?
Well, I have looked at them on many occasions, and I haven't, when I was in training, DTI didn't exist. So like many other things in radiology, when new technologies come about, you have to learn about them. And so I have done that. I haven't taken a formal course, if that's what you're referring to.
Approximately how many times have you been asked to read or review MRI, DTI scans or images?
Well, I've reviewed them on a number of occasions. I couldn't give you an exact number. It hasn't been that many, probably less than 100, I'm sure.
And am I correct in that you are unable to provide an opinion regarding the PET scans?
That's correct.
Okay. Is that a newer type of imaging since you first started? Is that why, or something different?
Well, let me say one thing about that. I am totally unfamiliar with the use of PET in evaluation of head trauma. I have never seen that in my practice. I asked a friend of mine who's a radiologist whether he ever heard of it. He had never heard of it either. So yeah, I'm not offering an opinion on the PET scan because I don't do this specific type of scan. I've never really been asked to review those. But as I said, and I actually looked this up as well, whether PET is used in the setting of head trauma, and it's not. I mean, it is not one of the things that is recommended for evaluation of head trauma by the American College of Radiology. And, you know, I have to just say that I am not really going to offer a specific opinion on what the scan actually shows. But as far as whether it's utilized in clinical practice, in my experience, it has not been.
So you're indicating that you're not familiar with it being utilized in a clinical setting, but you would agree with me that PET scans have been routinely utilized in determining brain or traumatic brain injury in cases like this.
Well, again, I'm not familiar with the use of PET in evaluating brain trauma. PET is generally used for evaluating hypermetabolic areas in patients with cancer and things of that nature. But yeah, I can't offer anything further on that.
So a neurologist using, you're indicating that a neurologist would not use or would never use a PET scan to determine whether or not someone has brain injury, or that's beyond the scope of your expertise?
Well, I'm not commenting on what neurologists should do or shouldn't do. I'm not here to offer a standard of care statement about the neurologist.
So you can't say whether or not that is standard or not standard because you're not a neurologist.
As I said, all I can say is that in my experience, I have never seen this done before. So you can take that for what you wish, but you know, I've been in practice for 40 years. I've seen a lot of scans.
Okay. If this wasn't a standard type of scan, would these radiology facilities be conducting these types of scans?
I can't speak for the radiology facility. I don't even know if this, I don't have any information about this. I don't even know if it was done at a radiology facility.
Now let's go to the the MRI DTI scans, which you can and did offer an opinion on. Let's start with 13.
Okay.
You would agree with me that really 13 through 17 would be paired sequences or paired scans, right?
Yes, correct.
One being diffusion weighted imaging, and the other
Yes.
one being like a flare. I guess it would be a different type of setting on the camera, as you indicated.
Yes.
And you had differentiated between the difference of white matter and gray matter, right?
Yes.
Does not this scan show white matter that's deep inside the brain tissues is injured?
No.
No?
No.
Okay, let's go to 16, if you could. Would you agree with me that in slide 16, once again, we have the paired sequences of the diffusion weighted imaging and the flare 2 image, that the lateral ventricles are abnormally or notably enlarged?
That is absolutely false.
Which would indicate that there's really loss of brain tissue.
Absolutely incorrect.
Okay. Go to 17. Would you not agree with me? And once again, we're looking at two paired sequences of the diffusion weighted imaging and the flare 2 image, that there's at least in this slide that there's abnormal signals that are resonating in the images, or at least
There is no abnormal signal there.
okay. If I can have a moment, Judge.
Yes.
Thank you, Doctor.
Thank you.
Good to see you again.
Okay, very good. Reader?
No, Your Honor.
Okay, may this witness be excused?
You may.
Okay, thank you, Doctor. You're done testifying. I'm gonna close out the Zoom.
Okay, thank you very much, everyone. Bye-bye.
Bye-bye. Okay, very good. State, do you have an announcement?
Your Honor, the state rests its rebuttal case.
Okay, very good. Okay, so ladies and gentlemen of the jury, we're going to take a 10-minute break. I'm going to allow the parties a chance to kind of get their notes together. Then we will begin the final closing arguments for the penalty phase. Okay? All right, very good. See you in about 10 minutes.
All rise.
Oh, I'm sorry.
Oh, no. Okay. Hold on. Capable of growth, redemption, and maturity. Okay. Okay. Sure. And then okay. Print those up. Oh, we'll have people print on both sides. Let me know if you print it on both sides. Oh, bother. Okay, throw it out. I don't know why it does that.
Switch it over. Okay. Okay. Yeah.
That's the one. Mr. Bolt, can you grab,
Yeah. That's fine. That's fine.
anything else I can do for you, Scott?
No, that's great. Thank you. No, no audio. Okay, thanks.
And Ms. Finkelstein, my JA cleaned up the margins, I believe. So here is updated mitigating for Sean Gathright. Welcome. Okay. Okay, you guys ready to go? but it might just go to another page. Hold on. I know, but she had to reprint because the other two added, and so. It may have thrown off the margin, so hold on. Hold on. Okay, yeah, so it did bump off 12 for Rashad Murphy, so that should be page 10. Okay, what's going on? Yeah. Okay. Okay. I understand. Yeah. Okay. Sure. Okay. Okay. So we're getting ready to, if I could ask the bailiffs just right there in front of me, just scoot over a little bit, because I got to talk to the audience a little bit. So we're getting ready to go into the closing arguments regarding penalty phase. And I know this is obviously very sensitive and difficult for family members, for the victim, for the defendants. And the courtroom is open. You all are, of course, all welcome to be here, but you cannot make any audible noises. You can't shake your head. You cannot have any type of response to any of the arguments that are made. And if you think that's going to be difficult, I would ask that you please just remain outside. You can watch and listen from the lobby, but when you're in the courtroom, everyone has to maintain their composure at all times. And then if you're unable to maintain your composure, I'm gonna have to stop, send the jury out, send you out, and tell you can't come back in again at all. So I'm not anticipating there's going to be a problem. I just want to make sure everyone understands, because I know this is very sensitive and difficult and challenging. Okay. And I acknowledge that, but we are still in the courtroom and everyone has to maintain their decorum. Okay. Are we otherwise ready to go? Okay. Mr. Hernandez, you ready?
Yes, sir.
Ms. Finkelstein, you ready? Ms. Toomey, you ready? Mr. Petridis, you ready? Okay. All right. One last.
All rise.
Okay, very good. Everyone have a seat. Welcome back. All right, we are ready to proceed. Mr. Harmon.
Police court
Yes.
counsels. All four of these defendants, they all sit over here at this L-shaped table. They sit over here and they are convicted because last week, 12 of you went back there and you came back with a just and a true verdict, convicting them. And they sit there in their guilt. They are convicted conspirators, convicted killers. They are convicted murderers. There is no doubt about that. What this is about is an entirely different thing. What you're here to decide today and going into tomorrow is what is the appropriate sentence for these defendants. They have been convicted, as the state told you in its opening statement, of planning and acting as a team in a concerted effort with one common goal: murder. Murder, the most evil and the most wicked crime that there is, the taking of another human life. And the evidence in this case has clearly demonstrated to you. I doubt any of you had any issue back there determining when you were deliberating that this was a premeditated crime. The court is going to instruct you tomorrow when you go out after all of the closing statements. She's going to read to you again the law on premeditation. And you remember that law from last week. You remember it? There has to be enough time to allow reflection for there to be premeditation. And clearly in your verdicts, you have found that. You would not have convicted them of conspiracy because you can't conspire. You can't have 4 people conspiring without premeditation. Was there premeditation in this case? Yes, but there was much, much more than just simple premeditation. Because when we talk about reflections, what are we talking about? Reflecting, having time to reflect. We're talking about decision making. Making a decision and acting upon that decision. That is reflecting. Solving a problem. That is reflecting. These defendants, in this case, did this for over 2 weeks at least, making decisions, solving problems, working through their plan. This is much more than simple premeditation. Premeditation can occur in a matter of moments. Let's look at the evidence of the heightened level of premeditation. These 4 defendants, by June 6th, the evidence tells us, had already planned, had already conspired, were already teaming up to snatch Charles Jones' life from him. June 6th. You recall this? The X Spaces discussion that was going on between Isaiah Chance and the victim in this case, Charles Jones. And what happens after that communication between them? That's what happens. Sean Gathrigh's phone has communication from his co-defendant Rashad Murphy's phone at approximately 11:18 hours. And shortly after that recording was obtained by the Jacksonville Sheriff's Office at 22:36 hours of Isaiah Chance arguing with Charles Jones. You remember his words. Hey, Julio, how's your foot doing? Make sure, this is out of Rashad Murphy's mouth. Make sure, brah, in a good headspace, before he go with his move, we got bigger shit to tend to. They ain't worth an inward energy right now. That's directed at who? That's directed at his teammate, Sean Gathright. And what does Mr. Gathright do? 17 days before this murder happens, he likes that. He likes it. And then he replies, I ain't heard from bro today, but I'm going to check in with him. And then Rashad Murphy texts back, he probably not going to pick up. He on IG letting these N-words get him out of character. He turned up on that MF right now. And then Mr. Gathright. Damn, all right, let me see what's up. So what does that tell us? That tells us that the plan was already in place more than 17 days before. This plan had been birthed, hatched, and formulated before June 6th. Before June 6th. This conspiracy and this premeditation spoke to a much higher level of premeditation and spoke to a very, very cold-blooded motive, a planned execution. As Miss Doherty told you last week, this was a hit. This was a hit. This kind of advanced planning, where that evil and that type of wickedness to take somebody is dwelling in a person's heart, and in this case, a team of people, problem solving, making decisions about it, working their way through this, developing the plan as they go along. A plan to not just murder, but if necessary, inflict carnage. And we saw that in the evidence. They were going to take out 6, and they were going to take out whoever might be there that might be in 6, because why not? And anyone else standing around, anyone else that might get in the way, that's just collateral damage. Now, why is the state going back through the facts with you? Because in the aggravating factors that you're going to be instructed on in this case, we are relying on that evidence. We are relying, as you saw, solely on our evidence from the guilt phase of this trial. Now, we did present some evidence. That evidence goes to rebut their suggestions of mental health mitigation, which you have seen have completely been rebutted and completely disproven. It is because of the extremely heightened level of premeditation in this case that the state, is presenting you with the aggravating factor, one that the law speaks to, of very cold-blooded murders. The aggravating factor of cold, calculated, and premeditated, that this murder was committed in a cold, calculated, and premeditated manner without any pretense of moral justification. That is the aggravating factor. We see in that evidence, the X spaces evidence, we see that evidence of this existing weeks before, but we see more than that. We see a conspiracy where its members are trying to ensure its integrity, its secrecy, and that it stays intact, and that nothing ruins the plan. Nothing gets in the way. I want to talk and walk back through the evidence in this case with you. Let's take a look at what occurred in this case. Mr. Murphy with his fully automatic Glock. And I'm going to come back to that because there's a few things I'll be pointing out to you in this evidence. It's very rare, folks, that an execution is caught on video like this. Look at the teamwork. Look at the precision. Look at the efficiency. That evidence alone, standing alone, without the X spaces evidence, without the Airbnb evidence of no one going through the front door, without all the other evidence, the evidence of Mr. Chance and Mr. Gathright coolly, calmly, businesslike loading up that Impala. Without any of that evidence, you could look at this alone and your common sense would be screaming at you that this is the product, this type of murder, it's the product of heightened premeditation. That doesn't happen without conspiratorial premeditation, planning, wearing disguises to cover their identities. And not just disguises, folks. They're wearing all black to hide in the darkness, to hide their skin, to hide their faces. They're wearing hoodies. These are disguises. These are items that they brought with them as part of this plan. This alone, this evidence and the efficiency, the positioning demonstrates the premeditation and the planning that went into this. And this evidence alone would be sufficient evidence beyond any doubt that this was a product of heightened, cold, calculated, premeditation and murder. The tenacity that occurs here, the lack of hesitation that occurs. This is a fully formed, committed mission that they are on that is immediately executed. As soon as the opportunity presents itself, they come out of the shadows where they're hiding. And we saw Mr. Davion Murphy, who snuck down behind those cars. And you heard me asking these forensic experts, isn't that significant that he did that? That he had the mindset and cognitive ability to hide behind the cars to avoid being detected by a very wary victim, someone who had his life almost taken 9 months before in an attempted murder that Mr. Gathright is connected to by physical scientific evidence. A very wary prey that because of their advanced planning, they were not going to allow him to get away. And we saw that in the tenacity of this, how Mr. Gathright continued in a persistent fashion, chasing after the Charger, pumping rounds into it. And then we didn't even get to Davion Murphy following down behind the cars and unloading down the west side of the hotel. So this is the aggravator. The first-degree murder was committed in a cold, calculated, premeditated manner without any pretense of moral or legal justification. Cold. Cold means the murder was the product. Calm and cool reflection. Calculated means having a careful plan, a plan that is carefully constructed or prearranged, designed to commit murder. In the instructions that Judge Sisko will give you, she will read to you and you will see that is the exact same instruction you got earlier on premeditation last week. But below that is her distinguishing this aggravating factor from simple premeditation. The aggravating factor to apply has to have a heightened level of premeditation demonstrated by a substantial period of reflection. A substantial period of reflection. Without any pretense of moral or legal justification. So what does this mean? It simply means that there is no claim of justification or excuse, even if it was insufficient to reduce the degree of the murder, that it would rebut the otherwise cold, calculated, or premeditated nature of this murder. Folks, there is no way to rebut the premeditated nature of this murder. There's just simply no way. There's way too much evidence of it. It is part of this. It's part and parcel of what we watched on that video. You cannot separate the two. To commit that type of crime would be impossible on the spur of the moment. That crime doesn't just speak of a lack of impulsivity. Remember hearing that term earlier in the last day or two? It doesn't just speak of a lack of impulsivity. It screams that this was extremely planned, that this was a designed mission. Rashad Murphy, let's talk about his participation in this plan. And I'm not going to go back through the amount of evidence that I covered with you in opening. I know that was a long process. The state wanted to give you an overview of this massive case full of evidence because of the just incredible investigative efforts of the Tampa Police Department and the Jacksonville Sheriff's Office in this case. Mr. Murphy obtains the Chevy Cruze, the silver Chevy Cruze. That's his first part of the contribution to this case. The car that's utilized as surveillance and as a spotter car, a car that's outside of the circle. Then Mr. Murphy on his Airbnb account, sending his ID and reserving that Airbnb. And now we see the teamwork coming in. Right around the same time, within minutes, you remember in the evidence, Isaiah Chance receiving a $390 payment from another gang member, an ATK gang member, J. Breezy, sent to his Mr. Rich Off War Cash App. And that payment is made to Airbnb. It's paid. And that is established and that's arranged. We have that done over a day before this murder happens. And then we have this video. If the video of the murder itself doesn't establish how premeditated and planned, we need only look at this video, because even if you got rid of the X spaces discussions and you didn't have the earlier in the morning paying of an Airbnb, and you have these two defendants, Mr. Gathright and Mr. Chance, businesslike. Look at him. Look at the confidence that Mr. Gathright carries with him. They could very well have been packing to go on a cruise or something, and they are packing up that Impala with high-powered rifles, with ammunition, with disguises, the tools they would need to carry out this mission. That's in the afternoon. That is hours, 20 hours or so before the murder happens. And then when they get to Tampa, and they have to drive, remember, because this conspiracy now is traveling from Jacksonville down here to Tampa. They have to travel for 3 hours to get down here. And they're coordinating. We saw that in the LPR, that both these cars are following and coordinating, again, showing advanced planning. But when they get here, we see this real-time demonstration of premeditation on the part of Mr. Gathright. And I'm gonna come back to that. Not too long after that, after Mr. Gathright is going through the Airbnb app and utilizing all their filters and searching and trying to find Charles Jones' Airbnb and trying to get an address for where he may be, utilizing the description that he is seeing on what's being posted by Mr. Jones. Not too long after that, we get this message on from Mr. Murphy. Man, you know, I want it myself. If I could, I would have had it. So many hoes there. I know somebody can get it from them. Get the B&B for me, gang. They're all trying to find the Airbnb. And then after the run to the McDonald's to get provisions for this assault team and this surveillance team, and they all have a dinner, a late night dinner to make sure they got enough energy, they start coordinating. And remember in the evidence, by this point, these two defendants, Mr. Gathright and Mr. Chance, they've already gone down to teasers. They've already cased teasers. They've already checked it out to get the lay of the land. They start coordinating. Mr. Chance is not using his phone because he's going to use his girlfriend's phone. He doesn't want to use his phone. He doesn't want to be tracked, and he doesn't want to be connected. So they start sharing information. Mr. Gathright stores Ms. Andrews' phone's information and his phone and a contact. They start sharing locations with each other. Now we're up to 208. They're still communicating with each other, coordinating. We see the coordination. We see Mr. Chance and his contributions starting here in the actual pursuit and the stalking and the hunting of Charles Jones. He's at teasers. As Miss Doherty told you He's wearing a hoodie. He's wearing a COVID mask. He's using his girlfriend as kind of a decoy or camouflage so that he's not standing around in the middle of the summer wearing a hoodie and a mask looking suspicious. It's just a young couple walking around in the parking lot. And they are there and they're observing Charles Jones and his friends as they're at teasers. Still communicating. Now they're trying to get Gathright to pick up his phone, maybe trying to FaceTime him, which we learned in the evidence is not collected in CDRs, call detail records. And they're telling him, pick up your effing phone. More coordination through the time that Mr. Jones is leaving. And now he and his entourage have gone to Truth 18, and they're at Truth 18, and they're getting ready to leave from there. And more coordination. Sharing location. So they can follow each other. Which leads us to the hotel. We know from the evidence, and I'm going to come back and I'm going to specifically address Mr. Gathright because I know you all have concerns about Mr. Gathright. He was 18 years old. The state's never hid from that fact. Is that a mitigating factor? Absolutely, it's a mitigating factor. And it's up to each of you to decide how much weight you want to give that. But we need to look at what Mr. Gathright did, and we need to look at how he conducted himself this early morning, well past loading that Impala. That's Mr. Gathright driving that Impala. And you remember, the assault team never would have been able to find that hotel if Mr. Chance and Miss Andrews hadn't have followed the victims, stayed just far enough behind and tailing them so they weren't detected, but able to see where they were going and relay that. Because Mr. Gathright, coordinating with his co-conspirator in this extremely premeditated plot, went directly to where the victim and his entourage had already gone. They had already pulled into the home to suites when Mr. Gathright was nowhere to be seen. Mr. Gathright immediately navigates that Impala around the north end of that hotel, passing all of those cars in that parking lot, passing all of the filled parking spots as he went around the north through that complex, around the Holiday Inn and back around to the west side. Now what we see in these photographs is Mr. Gathright navigating that car and making sure to do a three-point turn so he doesn't reveal their presence in this car that they have hidden. Now, if you go back to Truth 18, which I kind of skipped over, you remember Mr. Chance, the surveillance team. He gets out with Miss Andrews because they're just a young couple and they can get closer and make closer observation and give that intelligence to the strike team, the hit team, the assault team. Mr. Gathwright's driving the Impala. He parks across the street or parks, right next to the strip mall where Truth 18 is. But as they're getting ready to leave and they're getting information that he must have been receiving, Mr. Gathright repositions across the street and pulls up to that stop sign. And one thing you may have seen in the evidence, he stops and then he creeps forward so that he can see around that corner and see the entourage and see the victim's car. You heard Detective Ramos, this detective who did this incredible job and sat on the stand as a true encyclopedia of this case, telling you it is his opinion they were getting ready to possibly try an assault or to follow. But he gets there and he's also now part of the surveillance and he's staging, waiting. Here in the hotel parking lot, he is taking the precautions. He goes down and then he turns the car around and comes back without going around that corner or breaking a plane where they could be seen. He goes up around the corner. There he goes past the Tesla. They park. And then you have to think, There's no way they were driving around Tampa in June with hoodies and masks over their face for 4 hours. Because you remember, this starts at around 1 in the morning, 2 in the morning, and this is now 4:30 in the morning, 3.5 hours at least. So they had to kit up, get their hoodies on, pull these masks or gaiters or whatever they're using to cover their faces. Mr. Gathright has to retrieve that AR-15. And now he's handling it, and they're running, and they're acting as a team. These 3 individuals that are the assault team. And as I said, Rashad Murphy, or Davion Murphy, with his ski mask on, with only eye holes showing, with the 300 blackout, crouched down, making himself unobtrusive, trying to make sure that they conceal their presence, because this was all predicated and designed around an ambush. And you remember the state telling you in opening statements that they brought fire supremacy. That was part of the plan. That was part of this, to bring overwhelming firepower to this situation, because they weren't going to let Charles Jones get away. Not this time. Not this time. They were going to take him. He was not going back to Jacksonville. He was going to stay here in Tampa. So they bring 3 shooters with high-powered rifles and all of this firepower. In a few minutes, I'm going to talk to you about another aggravating factor that deals with that. But I will say it again. That firepower was brought for a specific purpose, to make sure he didn't escape, and anyone else that got shot, it didn't matter to any of these defendants. Not a one of them. No hesitation that they were sitting in front of a hotel with a packed parking lot. So now we're up to the point where they're going to commit this assault. And I want each of you to consider in this evidence, and I don't want to belabor the point, because I think you all understand, and I don't think any of you disagree, that there is heightened premeditation here. But the law speaks to that reflection element, and that's something you need to take into account. As I said, it's decision making, it's problem solving. And you think about all of the decisions in the problem solving that goes on. Mr. Gathwright's use of the Airbnb app and the VRBO app and that search alone, I'm going to come back to that in a few minutes. That sitting by itself is an overwhelming load of decision and problem solving, decision making. But think of all the decisions they had to make. Mr. Murphy had to try to coordinate Mr. Rashad Murphy to get that cruise. He had to talk to his sister or his brother's mother of his brother's children, and he had to coordinate with her, because someone had to go get the car. Either he had to go pick it up or she had to bring it to him. Every one of these steps required multiple smaller steps and multiple decisions and problem solving. Well, can you drop it off? We'll drive you back. Or can I pick it up from you? And then he's got to get someone to drop him off. And we know he's driving it when he goes to the Walmart, and someone there is driving it, and they come and pick him up when he comes out of the Walmart the night before. That alone just shows another example of the problem solving, the decision making, and then the back and forth with Airbnb and booking the Airbnb and finding an Airbnb that just happens to be 2 miles from Teasers and ends up being almost 1.33 miles, just over a mile from the murder scene, but in that same area right there around Busch Gardens. So now we have our assaulters. These 3 defendants, the 2 Murphys and Mr. Gathright. And I kind of want to walk through this with you, and I may have to use this laptop here to do it. I want you to look at where Mr. Murphy's rounds are hitting. They're hitting to the center left of that windshield. Mr. Murphy, Rashad Murphy, opens up first. He runs out immediately, starts firing with that fully automatic Glock. and put several rounds tracking up the hood into that windshield. Watch the driver's side of the windshield and the back window of the Altima. Now we're seeing impacts to the driver's side, and you can see the glass spraying upwards from the impacts through that automobile windshield glass. And we know Camilla Bentley is in that car on the right, the Altima. She's already got her foot on the brake. And watch when her car starts to move. First impact, second impact. And we know she takes the 2 rounds to the back of that car. This is efficiency. This is overwhelming firepower. So Mr. Murphy, Rashad Murphy, has stuck his head around the corner and looked. And the way that he and Mr. Gathright coordinate, it's almost as if they did a countdown, like a 3, 2, 1 or something. But they come out and they take up their firing positions quickly, efficiently, which shows heightened premeditation. And they're acting immediately. Watch Mr. Gathright. He will not even be in a standing position before he's opening fire. He is running into his position and starting to fire when his feet are moving. That's how quickly they wanted to put rounds before anyone could react to them. He's already firing and still moving at that point. But look where he's pointing. He's pointing towards the Charger. And then you see his muzzle swing to the right. Right there. He's making an intentional decision to redirect his fire after he has put 2 rounds through the windshield of that Charger. And now he's redirecting to the Altima, which they thought Tafa McRae was driving, a 6-block member. But in fact, Camilla Bentley had slid into place. Camilla Bentley, who was in the back seat. And for some reason, I don't know if you all looked at that when you were deliberating, but it's almost weird the way she slides in behind Tafa as he's getting out. And I believe her testimony to you was, I wanted to take charge. I wanted to get in the front seat. She would have been in that back seat if she hadn't have done that. And those 2 rounds were centered through the rear window. I'll talk about that later. Look at the purposeful, intentional behavior of Mr. Gathright here before Mr. Murphy appears up here, Davion. This perfect coordinated attack. He gets runs into the tree, almost falls down, turns, continues to fire rounds into that car. Now they're both firing into it. Almost perfect timing. And now Mr. Gathright is still firing. And look at where he's firing. He's firing to the northwest towards that Charger. But just look at the tenacity. That is purpose-driven behavior. This was something that had been in their hearts and minds, the point I'm trying to make, for weeks, for days. To murder someone, to take someone's life. And you see this overwhelming firepower. There was no consideration for anyone else in that area. None whatsoever. If they hit some 6-block members, that's all the better. And anyone who else, and this is another thing. When they're coming out of teasers or Truth 18, Mr. Gathwright's sitting over there at the stop sign. He sees the size of that entourage. He sees how many people are involved. He knows how many people are in those cars. Ms. Doherty pointed this out to you. Look at the accuracy of those rounds into the headrests. Both headrests taking rounds. Sean Gathright shooting an AR-15 chambered in 5.56 NATO. What caliber were the 2 rounds pulled out of Charles Jones' body? Well, the 1 round, what was its caliber? It was a 22 caliber class, 5mm class, which 5.56. The other round they could not figure out the caliber. Ms. Drew couldn't, but she could tell you they had consistent rifling and they appeared to be from the same type of rifling. Mr. Gathright put 2 5.56 round NATO bullets into Charles Jones' body. We don't know about the other bullet to the chest. That could have been from Rashad Murphy, and it would make sense. Davion Murphy, look at him crouching down, hurriedly getting into place, running behind those cars, staying concealed, staying in his hiding place. You remember, in his area where he cannot be seen because he doesn't want to reveal that he's there. They may try to go somewhere else. They want them to go that direction. They want them to go into that area, and they don't want them to flee or have a chance to get away. And then again, coming back, Mr. Murphy's tenacity, purpose-driven behavior. He's not giving up. He's not going to stop. And then quickly back to the car. Does that speak to you as someone who has a cognitive impairment? Rashad Murphy running back to the car. The image on the right, if you look at the direction of his head, he's looking towards the fleeing car. His direction is towards Charles Jones' Charger. And you can see in this image, he's now moved slightly forward and he's still looking in that direction. All of them were paying attention to what was going on with Charles Jones. Now, they finally get back to Jacksonville the next day. And for the first time in all the evidence, the ghost is revealed. Rashad Murphy, in person, showing up. Rashad Murphy, who tried to conceal, to try to protect the conspiracy 17 days before, when Isaiah Chance was talking to the victim and arguing with him, trying to get him to stop. You don't want to give us up. You don't want them to know what we're up to. You don't want to give them advance notice that something might happen. The ghost, who never appears on the ring camera at the Airbnb in Tampa. That takes thoughtful, deliberate action in and of itself. None of these defendants appear on that ring camera on the 22nd when they get there. They're going in and out of that Airbnb, as Miss Doherty told you, all through that evening. Chance and Gathright are going down to case the teasers earlier in the evening. They're leaving to go. Chance is going with his girlfriend and Mr. Davion Murphy up to the McDonald's to get food, and they never appear until after everything is done. Before I move away from the cold, calculated, premeditated, I want to move back to Isaiah Chance and just kind of cover some of his involvement in this case. We talked about this. He's the one that actually pays through J. Breezy's contributions for the Airbnb. He provides the Glock with the extended magazine that is utilized by Rashad Murphy in the attack. He helps load the Impala. Now we see the photographs of him on the left. That teaser's on the right at Truth 18 with Miss Andrews providing the essential, critical, on-the-ground, real-time intelligence and reconnaissance back to the assault team. There's no way, as I said earlier, that Mr. Gathright would have been able to find where the victim went unless he was right on their tail revealing himself. The only way he knew to do it was because Mr. Chance told him. And when they needed him to come in for last-second reconnaissance, Remember how fast after he had staged across the street at the Embassy Suites area at USF, he comes flying back across Fowler, blows that red light, and pulls right in and drives right past the victim in the car that they all know is not going to be recognized. That's why Mr. Rashad Murphy had to solve that problem and go get that car. And now Mr. Chance is providing last second intelligence to the assault team. So he drives in, drives past, goes around the corner, encounters the Impala, goes right past it, does that 3-point turn, and then he comes back. This is him still going, and then this is him coming back. And we know in the evidence this is less than a minute before the attack occurs. That didn't happen for no reason. That was a coordinated effort. And without Mr. Chance's information and intelligence to them, they wouldn't have known for a fact where Charles Jones was sitting. If you look at the passenger side of that Charger, you can see Mr. Jones' red and white socks sitting up there on the dashboard, moving back and forth. I don't know if you saw it when you were deliberating last week, but when the attack occurs, you quickly see his feet drop down as he's trying to scramble into the back seat to save himself. But clearly, they were there for a purpose, and that was to tell the assault team exactly where Charles Jones was. When you're considering Mr. Chance and Mr. Gathright, you need to consider their contributions to this murder and their role they played in this murder. Without these two defendants, this never, ever would have happened. It never would have happened. Without Mr. Chance providing that real-time intelligence, they would not have been able to track Charles Jones. They would not have been able to orchestrate this attack. Mr. Gathright, we know that the attack, this whole thing that day starts where? It starts at the Gathright household. In the Gathright household out in the suburbs in Jacksonville. And again, we see this extremely confident defendant, Mr. Gathright, loaded for bear, loading up his car as if they're going on a vacation, just as casual as could be, without a care. He and Mr. Chance are discussing how they're going to load it, where they're going to put the items, more problem solving, more decision making. Back and forth. And of course, we know from the evidence, from the search warrant that was conducted at the Gathright residence, that Mr. Gathright was the armorer of this assault team. He was the weapons man. He provided the armament that was utilized, this weapon being utilized by Davion Murphy. That rifle being utilized by Mr. Gathright. And you heard in the evidence from the very compelling testimony of Officer De Jesus that that rifle was being utilized with a high level of skill, the sling that was attached to it being utilized to stabilize the rifle, and we saw its effect. 2 rounds right next to each other, and Charles Jones back, fired by this 18-year-old at the time defendant, right through the windshield, and then the 2 well-placed parallel rounds right through the back window. And then the brass catchers, which unfortunately for these defendants had those 2 shell casings in it from that matched the gun that fired the Glock that fired Mr. Chance's Glock that fired that Mr. Rashad Murphy utilized. He provided the modification to that weapon and manipulated the weapon so that there wouldn't be shell casings left. Not this time. Because you remember back in October of 23, in the first attack on Charles Jones, they were able to match shell casings from that scene to the shell casings found when these officers stopped Mr. Gathright. Those shell casings. And of course, Mr. Gathright provided ammunition as well as the rifles. So I want to talk to you about this. I don't have audio on this, but I just want you to watch for a few minutes what is occurring in this screen recorded video on his iCloud. Look at that time, 8:30, 8:40. That's a work day before the murder happens. That's 8 hours before the murder happens. And we know that this defendant, look at the problem solving right there in real time in that evidence, the decision making going on from, as Raul Benasco told us, a very mature defendant who can take care of himself. Look at him going through. And then we're going to see him start using the multiple filters. A property on the water, a property with this many rooms, a property that has a pool, a property with a barbecue, trying to figure this out. This evidence in and of itself is overwhelming premeditation. This just drips with premeditation. It's saturated with it. And it goes on. You remember in the trial when we played this for you, this goes on for minutes and minutes and minutes of tenacious, goal-oriented, purpose-driven behavior by this defendant. And what was the whole purpose of this? Was he looking for an Airbnb? Was he looking to rent a property? Was he doing anything of any kind of productivity? No. He's trying to find their prey. He's trying to find Charles Jones, their target, desperately trying to find him, actively trying to find him. That phone's not moving itself. That's his fingers doing that. Searching, looking. Now the filtering. When you're considering the weight of this aggravating factor and you're comparing it and weighing it against a significant mitigator that he was 18, this is what you need to look at. When you're assessing the value and quality that this was a cold, calculated, and premeditated murder. And remember, your considerations are to each individual defendant as far as their sentence. It's an individual sentence. But because this is a conspiracy, because they acted as a team, a lot of this evidence, you got to look at it as a whole. You got to look at it as a whole. Every one of them, this cold, calculated, premeditated aggravator applies to each of them. This alone, this is enough premeditation to convict 1,000 people of first-degree premeditated murder. But it doesn't end there, because at 1:30, this defendant is not done hunting and searching for Mr. Jones. Now he's going to utilize a technique, a honeypot. He's going to use a honeypot technique, if you've ever heard of that term. A honeypot, a lure. He's going to try to lure and get that information by luring it out of someone, by using this pretty young girl, Kyla, who unbelievably goes along with this. I need you to text Fat Boy. We never know who Fat Boy is. It's probably Xavier Edwards. About what? As I need you to text Fat Boy telling you, trying to pull up about trying to see him tonight. You know I'm gone. I've been FaceTiming him while I'm out. She doesn't really understand at first. He in Tampa right now. Make it seem like you know he's there. He had a B&B with 6. Be like, what's WYA? Where are you at? I want to pull up. I'm drunk and trying to F. Never mind. Then she says, we at Tier the club, because she's not following. You want to come to the B&B with us? Question mark, because she's not understanding. No, I'm in Tampa. I'm trying to see where his B&B at. Who B&B? 6. Fools. It's his B-day and Fat Boy with him. Not here in Jacksonville. No, they in Tampa. What? She still doesn't understand, but that doesn't stop him. He persists. Let me FaceTime. Play like you know it. Fat Boy going to Beezer's tonight or some shit like that. Clearly, this defendant was persistent that night and tenacious in his attempts to locate Charles Jones. And then we know that in addition to all of this effort and involvement in this case, because folks, the evidence in this case shows there is no defendant sitting over here. There is no defendant in this case who did more to orchestrate this murder than Mr. Gathright. They may be as involved in him, but nobody exceeds his culpability in this murder. He adds and provides the car for the assault team, the Impala. He drives all the way down there and takes the entire intelligence and surveillance team with him. We talked about this, how he drove around the parking lot, how he maneuvered and kept the assault team from being detected. That's on that defendant's shoulders in this cold, calculated, premeditated murder. And where does this whole thing end? Back at the Gathright residence in the suburbs in Jacksonville. Now, he's not there. No, this defendant's not there. He's over in Auburndale in Polk County, dropping the Impala off with his unsuspecting grandmother, leaving it with his grandmother, Miss Allen, and then driving off in her 4Runner, now loaded with all of that ammunition and all that other evidence. Before I talk about this aggravating factor, I want to talk about the cold, calculated, premeditated evidence in this case. This evidence alone and this aggravating factor alone, if we had no other aggravating factor, would justify a sentence of death for each one of these defendants. Standing alone, it would justify a sentence of death, because this is a boatload of premeditation. This is, like I said, it's enough premeditation to convict thousands of men. There could have been 40 people participating that each had just a little chunk of this 2 weeks, more than 2 weeks of premeditation. And they all could have been convicted as principals to first-degree murder. It's overflowing. And this evidence, as you saw in that trial, because we kept bringing it, didn't we? All the way up to the end. More and more and more evidence. In football, it's called piling on. And when we have the burden of proof, which we should have the burden of proof, because we're the government and we are here asking you to convict them of something, then we need to prove it beyond a reasonable doubt. But like I told you in my opening statements, we're going to prove this to you beyond any doubt. There's zero doubt in this case that they committed premeditated murder. And I'm very confident that every one of you found that when you went back there to deliberate. This aggravating factor, it stands on a substantial volume of premeditation, of evidence of premeditation, of heightened premeditation. This aggravating circumstance alone justifies a sentence of death. This aggravating factor alone and its evil and its wicked nature outweighs any of the suggested mitigation for any of these defendants. Any of them. They conspired, they premeditated as a team, and it applies to each one of them. This aggravator that either Rashad Murphy or Sean Gathright or Davion Murphy was contemporaneously convicted of a felony involving the use or threat of violence to another person. You can take out the previously part. That's another way of proving that. They were convicted of a contemporaneous violent felony when you all came back here with that just verdict finding them, these three defendants, guilty each of 3 counts, not 1, but 3 counts of attempted second-degree murder. And that's exactly what they did. Attempted second-degree murder. That is an aggravating factor that I've kind of broached and talked about a little bit already. They weren't going to just kill Charles Jones. He was the target, no doubt about it. But if there was someone else there, 6 block, they were going to kill him. You saw that in the evidence. So let's talk about each of the people who were affected in those counts. Victim, Gino Norris, 22 years old, not a 6 block member, but a lifetime friend or a lifelong friend of Charles Jones since they were in middle school. He was there to celebrate with Charles. This young man that you saw come in here, this man who talked in low tones, in a subdued voice. And you saw in the evidence when they went up the stairs at Truth 18, he kind of paused and leaned on the banister and waited for everyone else. He was there because he was Charles Jones' friend, not because he was a member of 6 block. But that didn't stop him from catching a round in his arm. Xavier Edwards, the driver of the car, who is a 6 block member, 19 years old at the time, he took multiple rounds into his shoulder. He had grazing wounds on his hands, probably because his hands were up where all of the glass was shattering on the steering wheel. This young man most likely saved not only himself, but Gino Norris's life by pressing down on that accelerator and driving through that massive wall of fire in that vortex between Davion Murphy and Sean Gathwright's high-powered rifle fire. And then this photograph, because I want to speak about this a little bit. We're going to talk about this. Look at their faces. Look at that. That is from a body-worn camera. That's not a pose. That's in the middle of what's occurring. That's a screenshot from a body-worn camera. Look at the stunned look on Gino's face. And look at the expression on Xavier Edwards. We heard testimony this week about this was a traumatic event. Remember that coming out of Mr. Gathwright's mouth? That's trauma right there. That evidence. That's real trauma being reflected in real time as it's being suffered. And we saw these photographs of Xavier Edwards being treated in the hospital for all of his wounds. These men still having projectiles in their bodies. That photographs should be on a horizontal, but that's Gino Norris in the hospital. He was able to go home later that day with his father who came and got him. And this is what I was talking about earlier. Look at the placement of those rounds from Mr. Gathwright's rifle, because there's no doubt he's the one that fired those. The one on the right went out the windshield. The one on the left went through this young lady's right arm. Camilla Bentley, 22 years old, completely unrelated to anyone in this case. She's a friend of Miss Albritton's and just happened to be tagging along for the party. And somehow somehow, by some providence, she knew to slip into that front seat. Because I can tell you, if you're looking at this photograph, let me see if I can go backwards. One of those rounds may very well have gone right through her head. Yeah. We have 3 attempted murders in this case, only by the grace of God. And you can see the round coming out of that windshield. And then this is this, and before I guess I move on to that, let me talk about this aggravator. The fact that these 3 defendants, the Murphys and Mr. Gathright, shot and killed Charles Jones and then attempted to murder these other people who were in the cars, Camilla, Gino, and Xavier Edwards. That is an aggravating factor. That is a violent felony offense that you have convicted them of. And that is an aggravating factor. And there is absolutely zero doubt about it. It's been proven in your verdicts. Your verdicts, you've already found that this aggravator exists beyond a reasonable doubt. That aggravator alone would justify a sentence of death for these 3 defendants. But when you couple it, when you add it, and its weight and significance to the heightened premeditation in this case, there's no comparison. It blots out the mitigation that's been presented to you for those 3 defendants. The first-degree murder was committed by a criminal gang member. Now, I think Mr. Petrides had come up here in his opening and had told you what you all already know. You already basically have found that this is proven by proof beyond a reasonable doubt. The wording that you were given, and that's a sentencing enhancement, is that the crimes were committed by a gang member or associate, because both of those would qualify. You remember the gang detectives talking about there's criteria numbers that have to be met in the Florida statutes for a gang member or for an associate. The state has no doubt that when you deliberated, you found that all of these defendants, other than Mr. Gathright, are gang members. But now you will have to make a finding of that the state has proven beyond any doubt that they are. You will be given the same instructions about the criteria and that so many have to be met. Is that an aggravating factor in this case? So I want to ask you about that. Does common sense say that it is? Because if one of these defendants who was a gang member, let's just take Mr. Chance, just as an example, if he had got into a fight with his girlfriend or found out something about her that he was upset about, and he went out to his car and retrieved a gun and he loaded it and he walked around the block and he cooled off and he came back and decided he was going to kill her anyways, and he went and murdered her, that would be premeditated murder. That would be an aggravating factor because he's a gang member. But in that instance, the gang membership would have nothing to do with that murder. It'd be unrelated to that murder, and it'd still be an aggravating factor. But here, this is the heart of this murder. It's the heart of this plot, this plan. All 4 of these defendants share the same motive, to take out Charles Jones because he is in the opposition. Mr. Gathright we don't have this aggravator against him, but he clearly has allegiances and associations. So it goes to the CCP, the cold, calculated, premeditated aggravator as far as Mr. Gathright. His motive would be relevant to that to show the heightened premeditation. But it is not an aggravator against him. You cannot consider it as such. But these other defendants, yes. It's not only an aggravating factor, it's an essential part of the cold, calculated, premeditated manner that the murder was committed in, because it's their motive. It lays at the heart of this case, and that's what makes it so aggravating. When you couple that, that the reason they're doing this is because they are criminal gang members, and they're taking out an opposition criminal gang member. That's what aggravates this murder. And it applies to these 3 defendants, the Murphys, and now Mr. Chance. Not Mr. Gathright. And we know what their motive was. We can take it right out of Young and Ace's song that was written and produced and uploaded just a few days after Charles Jones' murder. Davion Murphy, Shug Spaz. Davion Murphy throwing gang signs. Talk about cold-blooded. They're talking to him about a murder, and he's in there throwing gang signs when they leave him alone. This is a proud gang member. He is a walking billboard of 1200. It's indelibly imprinted all over his body, from the 1200 on the back of his neck and his upper traps, all over his body, with the members of 1200 who have been murdered or killed. Rashad Murphy, sending out the next day, was barely afternoon, and he's posting his motive in this murder, throwing props to Prosper and Junior, Get Back Day. They are the 187 babies. And we all remember what 187 stands for, right? The California statute for murder. You remember this slide, and you see Mr. Murphy. We saw still shots of Mr. Murphy there. He's throwing an upside down 6 and a bully down sign. And those videos that he was in with numerous other gang members, including WAPA and Spinabins. And then Mr. Chance up on the top left, an ATK member. Mr. Gathrights photo is in there only to show that he is associated to that gang and has allegiance to them. Again, you cannot consider it as an aggravating factor with him. Mr. Chance posts his motive right after the murder. Earlier than Rashad Murphy, we see Tilly, his good friend that was murdered just hours before the attempted murder on Charles Jones in October of 23, the murder that Mr. Chance's best friend and buddy, Sean Gathright, is connected to, and the evidence. And we see Mr. Chance sitting there in that back seat with a ghost over his mouth. Mr. Chance throwing 1200 signs. Mr. Chance with his bully down sign. You remember, Ms. Doherty made a great point in her closing statements. It's up in an area of his bedroom. First thing he'll see in the morning, last thing he'll see at night, in a place where a lot of people will put a crucifix or some other religious symbol. And we don't need to guess at Mr. Chance's motives. This is him speaking directly to other members of his gang, ATK. Who's faking and who not? Who really contributed to the war? I can count on one hand who effing sliding and done killed shit and who don't, or who didn't, boy. What the F? I'm talking about confirmed kills, bitch. Let's be for real. And he's speaking directly about his anger, if you remember the other slide, about nobody doing nothing about Tilly. Nobody's doing anything. And in his social media posting, he misses his friend, Tilly, who you recall was shot in the Uber just a few hours before the attempt on Charles Jones' life. So now I want to discuss something with you real quick. And I'm going to try to make this quick. As I've said, the essential motive in this case was Charles Jones' affiliation with 6 Block. He was a gang member. We put on evidence of that to show you he was a certified gang member of 6 Block. The opposition to these 3 defendants over here who are gang members He wasn't just a gang member. He was the face of 6 Block. He was the spokesperson of 6 Block. He's the one visiting his friend and then goes over to the grave of the opposition and is giving it the finger and posting the photo and dancing on a grave with the photographs of those young men that were shot at the town center shooting. That's Charles Jones, and that's why he was murdered. It goes to the heart of this case. But I want to talk about Charles Jones because just like these defendants whose relatives and family members you heard from, the mothers and the grandmothers, Charles Jones was a son too. Charles Jones was a brother. Charles Jones had a mother, Miss Mays, and you heard our employee from our office read her statement for her because she couldn't come in here and give it. Emotionality is not allowed on the witness stand with those types of statements. It's called a victim impact statement. It's not aggravation. You can't consider it as such. But it gave you a little peek into the fact that Charles Jones was a person. Charles Jones had a family. He did a lot of things that were bad. He did a lot of things that were despicable. His songs were full of violence. You know, it's kind of the elephant in the room, and I want to talk about it. He doesn't enter this case with clean hands, and we've never hid from that fact. From the state's opening statement going forward, we have embraced it because it's the motive in this case, and you need to understand who he was. Everyone in this country is entitled to due process of law and to the right to life. And that's why you heard a victim impact statement. The courts, our courts, are the levelers. They're the levelers. Everyone is level under the face of the law, under Lady Justice and the even scales of justice. Everyone walks into the courtrooms level. The courts are the great leveler. You remember that quote? If any of you all are American literature fans, probably the greatest work of fiction in this country. And I can also cite to a more recent work addressing this issue, another work of fiction, where the title character said, if he doesn't count, nobody counts. And if Charles Jones doesn't count under the law, then nobody counts. I wanted to address that with you because I know that's in your minds and in the back of your minds. Every citizen in this country is entitled to due process and to pursuing and having the right to life. And Charles Jones had the right to life. Now I want to talk about mitigating evidence. I've kind of addressed it here and there. It's the defendant's burden, the individual defendants in this courtroom that have presented mitigation, to prove it to you by the greater weight of the evidence, meaning it's more likely than not that it exists. So when you're considering the mitigation, you've got to determine, number one, has it been proven? And number two, what value or significance does it have to you as it pertains to sentencing? As it pertains to sentencing, does it mitigate against a potential sentence of death? Because that's its purpose. It's up to each and every single one of you to make a personal moral decision about that. So I want to talk to you about your consideration of mitigation in this case. You have heard that we are here because this is about Sean Gathright, or this is about Isaiah Chance, or this is about one of the Murphys. And that's not why we're here, folks. We're here for you to determine what is the appropriate sentence for the murder of Charles Jones. What is the right and the just sentence? That's your determination. To make that determination, you have to consider evidence of mitigation. So you certainly do have to consider evidence about Mr. Gathright, evidence about Mr. Chance, and evidence about both of the Murphys. And you have to consider that in isolation to that defendant alone, because your sentencing is going to be specific as to each one of those defendants, and they will be sentenced, each one different on their own by you in your verdict. So you have heard a lot of evidence as we've progressed through each defendant. I believe, if I recall, we started with Mr. Gathright, and then we worked our way forward from there to Mr. Chance, I believe, and then Mr. Davion Murphy, and then Rashad Murphy. In each one of those instances, you heard a lot of people come in here and testify on their behalf. You heard a lot of people describe them, describe their upbringings, describe the support they may have been given or not given. You heard a lot of testimony in this case about them. It's about them because it's mitigation, and it goes to mitigate potentially against the sentence of death. But your role here is to determine what is the appropriate and just sentence. You have to consider that. So I want to talk about, I'm just going to walk through these mitigators. They're different, and there's a list of them. And I'm just going to remind you that the judge will tell you each of you must decide what weight is to be given. Different factors or circumstances may be given different weight or values by different jurors, and that's fine. That's fine. Each of you will give these different values, maybe you'll agree with each other on the mitigating and aggravating factors and the mitigating and aggravating circumstances. But the one thing you will not hear in this instruction is that you are to go back there and sit there and make your decision and not discuss your decision with anyone else. In fact, the judge is going to tell you in these instructions, she's going to encourage you to deliberate. Yes, your decision as to what sentence is an individual sentence, it is, but you are encouraged all through these instructions in your deliberations, when you deliberate, to have discussions amongst yourselves about what the right and just sentence is, and also what weight or significance you give to mitigation in this case versus the aggravation in this case, the aggravating factors. Isaiah Chance's age at the time of the offense, he was 21 years old. Is that mitigating? It is a circumstance you certainly should consider. It's up to you to decide whether a 21-year-old man, whether that is mitigating. It is young. It's very young. Everyone in this case is young. But other than Rashad Murphy and his cousin, they were in their late 20s and 30, I think 29 or 30. 21 is young. It is. And it should be considered as mitigation. But it's up to you, each of you, to determine what weight you're going to give that or significance you're going to give that. No significant history of prior criminal activity. That should be given weight. Isaiah Chance suffers from borderline intellectual disability as well as untreated ADHD. I think that is not proven to you, even by a greater weight of the evidence. I think the evidence in this case, through the state's expert, Dr. Werner, this morning, has proven to you, and also through the cross-examination of Dr. Harding, that his ADHD he had was when he was a child. That's when he was a child. Was it untreated? Yeah. You know why it was untreated? Because that defendant, Mr. Chance, has a wonderful, loving, caring, involved mother who was concerned about him and having Ritalin and other drugs pumped into her child. And she decided against it. Some people decide to have their children treated with that, and that's fine. But she decided against it. And Dr. Werner told you she did not find any evidence, none, to suggest that he suffers now as an adult from ADHD. He was diagnosed with it in the schools by somebody. But you also heard Dr. Eisenstein testifying on behalf of Davion Murphy told you young men or young children, little boys, are frequently diagnosed in the school systems with ADHD, especially a decade or two ago. Lots of little boys were diagnosed with it. And I'm not suggesting that that mitigates against that, but just you need to consider that in the actions of his mother, who was, if nothing else, a wonderful woman who came in here on her son's behalf, who loves her son and her son loves her. They have a good relationship. And she doted over him when he was growing up and tried to help him in any way she could. His decision-making was impaired by borderline intellectual disability. And that's according to Dr. Hardy. Dr. Werner told you, no. Isaiah Chance is not in the borderline range. That's below the low average range. He's in the average range. She talked to you all about his vocabulary, his syntax, the way he spoke to her, about how he was able to convey to her his passions, his dreams. He wanted to be a merchant marine. He was a longshoreman who had to go through the application process to get a TWIC card to be able to get into the ports, which are regulated by Homeland Security and TSA. He held down jobs. He went through interview processes. Mr. Chance did not personally carry, display, use, or threaten to use, or attempt to use a firearm during the commission of the offense. Well, he didn't, but Mr. Chance supplied. He supplied and certainly carried from his BMW into the house, and it went along the trip. It went along with them all the way down in that Impala, and Rashad Murphy utilized it in the commission of this very, very planned and premeditated murder. I would suggest to you that has zero weight. I would suggest the evidence has clearly disproven that Isaiah Chance has borderline intellectual disability or ADHD. Isaiah Chance cherishes fatherhood and has a great relationship with his 3 children. That's mitigating, and you should consider it. It's been proven. Isaiah Chance has a loving and close relationship with his parents, his sibling, his grandmother and godmother. I can't imagine a better grandmother. The state cannot imagine a better grandmother than his Nana. And his mother and his father, who appeared by Zoom and talked about his son. So yes, that's been proven. Is it mitigating in this case? That's up to you to decide what weight you want to give it. But it is a proven mitigator, been proven by the greater weight of the evidence. He helped his grandfather, when the grandfather had cancer. We heard his Nana, his grandmother, come in and tell us about him going on the trip to Atlanta and helping and with their move up there so that the grandfather could get treatment. And that has been proven by the greater weight of the evidence, and it certainly is mitigating. It's up to you to decide how much weight you want to give it, because ultimately you're going to be weighing these mitigators against the state's aggravation to decide if our aggravating circumstance and value and significance outweighs that mitigation as it pertains to this murder, as it pertains to the just and right sentence in this murder. I'm going to keep saying that because that's your ultimate decision. That's your ultimate decision. What's the just verdict? He attended church with his stepfather and his grandmother. He was raised in the church. There's no doubt about it. Those are strong Christian people, and they raised him. Although his grandmother didn't want to agree with Miss Doherty that he was raised in the church, and that's fine. That's understandable. The state has is completely understanding of that. I'm sure she didn't trust us as advocates in this case, but the point came across very well. He helped his mother around the house. His mother came here and told you that he did. It's been proven. He was motivated preparing for a career as a merchant seaman. That's been proven. That was talked about also by our doctor, Dr. Warner. He was described as quiet, respectful, and a nonviolent child by family members. He was. And you can remember his mother and father describing him, and his grandmother, as not only quiet, respectful, but smart. Smart. He was a smart little kid, and he's a smart man. As Dr. Warner told you, from how he discussed things with her and his ability to communicate. He has the continued support of his family. He does. That's clearly proven. He is a son, a brother, a grandson, a father whose life has meaning to others. I think these are getting repetitive, and there's a total of 18 of them that apply to him. And again, as to Mr. Chance, the state of Florida is seeking two extremely powerful aggravating factors. This was a cold, calculated, premeditated murder, and that he was a gang member, which lays at the heart of this case. So it's not, the judge will tell you, a mechanical process or a numbers game. Well, I thought I had a slide in there. It went somewhere. But she will instruct you that it is not simply adding them up. And that makes sense. You need to determine the quality. We've talked to you all about that since back in jury selection. He is capable of growth. He's capable of redemption and maturity because of his young age. Well, he certainly is capable of growth and redemption, and his family talked about that. So the state has no qualms with that being proven. And then the existence of any other factors you may want to consider, and his background, character, or life or circumstances. So what does that tell us, and what does that portray about Isaiah Chance's life? It also portrays this, and you saw it in the cross-examination of these witnesses, which, if you saw, was not very cross at all. He had loving people around him. He had his mother. He had his father. He had his grandparents, his Nana and his Papa. He had, his mother was separated or divorced from his father, but then came along Mr. Nix. Mr. Nix, do you remember Mr. Nix? Who has that wonderful program he runs in the streets of Jacksonville to try to interdict and stop this from happening? Mr. Nix, who was not blood related to Isaiah Chance and his siblings, but would pick them up from school. The man who wouldn't accept one-word answers when he asked Isaiah Chance, how did school go today? What did you find interesting? What subject matters? And other conversation. He would debrief them, he said. It was kind of tickled me a little bit, the military terms he was using. But he would spend time, and that's what parents are supposed to do. What better father figure? What better role model than that he made and had him involved in martial arts, which is part of this SEAL program that he runs in Jacksonville. He couldn't have had a better environment of loving, caring, supporting people surrounding him as he was raised. He had every opportunity. He was taught, as Nana told you, right from wrong, taught about the 10 Commandments. Consider all of that when you're considering the weight of this mitigation. Sean Gathright, they will talk to you at length, I'm sure, about the fact he was 18. Is that mitigating? We've already told you it is mitigating. It's been proven by the greater weight of the evidence. It is the strongest mitigating factor that he has. It is the strongest mitigating factor. And I know it's probably weighing heavily on a lot of you. You need to give that whatever personal significance you deem fit. But again, I would encourage you to look at that in the light of the totality of the evidence in this case, his youthfulness. Their own witness, this corrections specialist who has worked at all of these jails and worked at all of these prison facilities and been around all kinds of inmates, from maximum security prisons all the way down to women's prisons to all types of programs, told you this defendant, Sean Gathright, is mature and he can handle himself. he can handle himself. And we saw in the evidence in this case. We saw it in the evidence in this case. You need to consider that. You need to consider his behavior and how he acted, how this individual, Mr. Gathright, drove this enterprise. He drove it. He literally drove it. He drove the assault team. He provided the weapons. He provided the fire that was directed into Charles Jones' body and into multiple other places, including Camilla Bentley's arm, and potentially into Xavier Edwards and Gino Norris. We don't know, because those projectiles were not removed for health purposes. He was 18 years old at the time of the offense. His age at the time of the offense, it's kind of duplicating itself. Mr. Gathright has a proposed 32 proposed listed mitigators. Again, the state would just simply encourage you to follow the law, that it's not a numbers game. It's not a calculation. He was raised in a military family with repeated parental deployments, resulting in frequent locations and prolonged separations. He was, but look at what he was able to do with that. You heard from his mother, and you heard from his prior stepfather, Mr. Harrington, a wonderful man, the Air Force man. You heard from Mr. Edwards, the counselor at the school that he got to go to, the magnet school, a school that not every kid gets to go to. And they all told humanitarian work there. He got to go to Cape Town, one of the most beautiful cities in the world. He lived in Okinawa, Japan. You heard Mr. Harrington say that, who's a pilot. And he got to fly to all these islands in the archipelago around Okinawa. Imagine that childhood this man had. All the opportunities, all the care, all the support and the love. And the state would ask you to compare it to the despicable and evil actions of this 18-year-old on June 22nd and in the early morning hours of June 23rd as he hunted Charles Jones. He was the driving force in this conspiracy, no doubt about it. Just like Mr. Chance's surveillance, it never could have happened without his participation. He is up to his eyeballs in this conspiracy and murder. He lacked a stable male role model or consistent guidance during formative years. That has not been proven, folks. I'm sorry, that has not been proven. You can't march all of these wonderful people in here and believe that. No way. Those grandmothers and his mother would never have allowed that to happen. He was subjected to verbal abuse by his father. It sounds like he was. It sounds like that's been proven. He was subjected to physical abuse and injury at the hands of his father. Maybe. We have that one story where he ran off and was in a park and his grandmother called him. And they got him out of that situation fairly quickly and moved him back here to the East Coast. He lived in an environment marked by fear, conflict, and lack of safety in his father's home. Maybe, but not for very long. That was intermittent, and it wasn't for more than a few weeks or a month, we heard in the evidence. He struggled with identity formation and belonging in adolescence. I'm not sure we heard anything about that. You may have a better memory than I do. You rely upon the evidence. He experienced isolation and a difficulty adjusting socially after relocation in adolescence. I would suggest the evidence is to the exact contrary of that. He was susceptible to influence due to his age. Did the evidence reveal that that defendant was susceptible to influence or that he was the influencer? Look in the evidence as far as that mitigation, because I don't believe the state would submit to you that has not been proven. His decision-making was influenced by peer groups in an unfamiliar culture. He had been here in Jacksonville for several years. They, I believe maybe in his testimony, tried to paint it as a violent environment that he was dropped into. Look at the evidence. Look at where he lived. Look at the photographs from the search warrants and the photographs of the exterior of that house and that driveway. He lived in the suburbs in a nice area. And you heard in the evidence that he lived in a nice area. He is described as a kind, respectful, and nonviolent by his family. I think they did describe him as such. But the nonviolent and respectful superlatives simply did not apply from June 6th moving forward, folks, through this murder and even afterwards. I'm not sure I would suggest to you, the state would suggest how respectful it is to drop a motor vehicle that's been utilized in a collaborated conspiratorial murder with your elderly grandmother who ends up getting pulled over driving it. He is optimistic and positive, and a positive support for his family and friends. I think that's probably been proven. He loves his sister, nephew's mother. I think that's been proven. He loved deeply by his family who have supported him. That's been proven, as I've already argued to you. He's described as calm, well-mannered, and non-confrontational. Well, he was certainly calm when he was loading that Impala, and he was calm when he was executing this murder along with his co-conspirators. Calm to the point of ice water in his veins. With that type of accuracy he was displaying with that rifle while moving. Trying to remember where I left off. Okay. He has the capacity to contribute positively. Maybe. Is a son, brother, grandson, and friend whose life has meaning to others. Absolutely. Absolutely. That's been proven to you. And again, you need to assign to that whatever weight you see fit. He has a desired potential to mentor, to influence others. It sounds like he does. He has previously fed the homeless, was involved in community projects in Mississippi when he lived with Miss Gathright. I think that's been proven. He traveled to foreign countries on mission trips for humanitarian purposes. That's been proven. He participated in educational international travel programs with exposure to broader opportunities. Absolutely, absolutely. The environment that Mr. Gathright and Mr. Chance grew up in, very, very similar. Wonderful grandparents, a wonderful and committed mother, wonderful support systems from Mr. Nix for Mr. Chance to Mr. Harrington for Mr. Gathright. But what separates these two defendants is the opportunities and possibly the material well-being of the family that Mr. Gathright grew up in. He lived in Japan. He visited Europe. He had every single opportunity, went to a magnet school, traveled abroad. He has entrepreneurial initiatives, including running small businesses. Sure. Yeah, it's definitely proven. If you want to find that mitigating, that's fine. He showed productivity at a young age, demonstrated desire to be productive, engaged in creative, constructive outlets, including photography and media work. At one point in his life, yes, he did, clearly. He has shown resilience, adaptability despite adversity. And you see one mitigator here kind of contradicting another. And that's what we heard in the evidence, how resilient and adaptable that this defendant was when he was growing up. Out of necessity, he had to learn to be. He could contribute significantly to the prison workforce. I'm sure he could. I leave that up to you to decide if that has any mitigating weight at all. And the existence of any other factors in Mr. Gathwright's character. So, speaking of the prison thing, I want to talk about Raul Benasco's testimony, because the man who's going to be paid $4,000 or $5,000 to come in here and give us this amazing news that prison is tough. Oh yeah, prison is tough. Life is life. Life without parole. That's a tough sentence. Is it punishment? Because you've heard that. kind of all through the beginning of this penalty phase, life without parole is punishment. Yeah, it's punishment. It certainly is punishment. And a death sentence is punishment. You need to decide what the appropriate sentence is. It's not an issue as to whether it's punishment. It clearly is punishment. It clearly is. And as if he's sentenced to this, on this crime, Mr. Gathright, to life in prison, he will be at a close custody level. There is some modification, Mr. Bonasco told us, could occur to his work and to his living environments, but it's not maximum security death row. It's a different whole ball of wax. You remember the whole air conditioning argument? I think everyone here knows what air conditioning is, and it doesn't exist on death row. The mitigating circumstances applicable to Rashad Murphy, there's 12 of them. He has no significant history of prior criminal activity. That's been proven. That's fine. Mitigating, yeah. His age at the time of the offense, well, he was 30 years old, folks. He was a grown man. I mean, 30 years old. That's not an issue as to whether that's mitigating. That has zero mitigating factor, or zero mitigating weight, the state would suggest to you. That is not a mitigating factor. He has a history of physical and emotional abuse as a child consistent with PTSD. All right, so that's probably the most for a couple of years. I think it was 3 years. But there was a real divergence while he was in there. Remember? He was placed with some foster family because his mother was a drug addict. And apparently the authorities removed him up in Georgia, St. Mary's, Georgia. And he went into a foster situation that was not very good. And he saw his little brother being physically abused. And I'm sure that, and I have no doubt the state has no quarrels or qualms with that being traumatic. That's traumatic as a boy to see that, a stranger beating on your little brother. But we also heard that the whole time that was occurring, his aunt and his grandmother was fighting to get him out of there. They were fighting to get Mr. Murphy, Rashad Murphy, out of that circumstance, he and his brother. And the Georgia authorities were skeptical about it because of what had occurred with the mother. And I think maybe his grandfather had some criminal history way back in early part of his life, and it was affecting that decision. Meanwhile, he and his brother do with this woman, Miss Dallas, who his aunt told us was a wonderful foster mother. He couldn't have had a better foster mother, Miss Dallas. She cared for those boys, and when the state came to take them, when her time with them was up, she fought to keep them from being transferred to another foster parent or another foster home. She loved and cared and supported those boys, and his aunt came in here and told us, and we may have heard that from someone else, I don't remember, but another family member may have told us about Miss Dallas. You remember the testimony? She would dress them up and bring them down here when their little sister was performing at church in Jacksonville, drive all the way down from Georgia. She would bring them down there to Jacksonville for family get-togethers. And they thought the world of her. But after about 2 to 3 years, Mr. Murphy went back to his family, went back to that environment that he lived in, which was a loving, caring environment outside of his mother. It was a loving and caring environment that he had. His aunts told you that in their testimony. He had and maintained a loving relationship with his family and friends while he was incarcerated. He absolutely did. He developed religious and spiritual awareness. Well, apparently he has. We saw some certificates where he's been doing that and trying to help out with Bible study. He loves his children, has been a good father to them. It sounds like he has. Sounds like Ms. Steiger told us that. And I know his aunts told us that he loved his children or does love his children. And again, another aggravator, a numbered one, it talks about him being removed from his home, placed into foster care. The state would tell you that most likely that's the most powerful mitigation he probably has. He has no prior felony convictions. That's true. We stipulated to that. He has displayed appropriate behavior and the ability to follow rules while incarcerated. That's fine. If you want to find that to be mitigating, he's in a controlled environment. And then any other existence of any other factors. The PTSD diagnosis, the state would suggest to you, is somewhat of a skeptical, the state is skeptical of that diagnosis and the evidence in this case. Dr. Collins testified to it and agreed. He, in fact, was looking for the collateral evidence that Dr. Werner examined in this case, the police reports, the interviews, and and that was her discussion about other defendants, not about Mr. Murphy's case, Rashad Murphy. He found evidence that he may suffer from PTSD. But as I pointed out to her in the cross-examination, this defendant not only participated in this conspiracy to commit murder and took all those steps I already walked through with you, all the things that he did to contribute to this, including trying to protect the conspiracy and trying to keep it hidden, which apparently is his forte, the ghost, who didn't appear until they got back to Jacksonville, was able to avoid the cameras. But his role, and the next aggravator I'm going to talk to you about, not only in the heightened premeditation, which clearly he was part of that planning, because he's telling them, we have this plan in place that we're going to do, and he needs to stop talking before they figure this out, trying to protect it. His behavior in the actual murder itself, with that fully automatic Glock pistol, that needs to be considered, because he's firing that at a fully automatic cyclical rate, with Mr. Gathright standing to his right, firing a high-powered rifle at a high rapid-fire rate. All of that percussion, all of those muzzle flashes, all of that violence occurring, not affecting him at all, not triggering any kind of a PTSD reaction at all. He coolly, calmly runs back to the Impala, almost like he's jogging, keeping his head turned towards the Charger as it flees, gets back into the Impala, and they flee back to the Airbnb, and then he's posting up get back day. And lastly, Davion Murphy. May I have one moment to consult, Your Honor?
Yes.
So Mr. Davion Murphy has suggested 13 mitigating circumstances. I'll try to move through these as fast as possible. The capacity of Davion Murphy to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. Absolutely not. That has been absolutely disproven. Everything about this case tells you that he knew the criminality. He wouldn't be hiding his identity if he didn't know the criminality of his conduct. Everything about this shows planning. It shows advanced thought, purposeful action, him pursuing the Charger, remember, and firing the rounds down the west side of the hotel at the Charger. Nothing about this supports that. And Dr. Werner confirmed it in her expert psychiatric opinion. He does not meet that. The felony was committed while he was under the influence of extreme mental or emotional disturbance. No, that was completely disproven. Dr. Werner told you, no, he doesn't suffer from any emotional disturbance or extreme mental disturbance. His age at the time of the offense, he was in his mid to late 20s. I think he was 26. He's in his late to mid 20s. He suffers from traumatic brain injury. I'm just going to echo the words of the last doctor you just heard testify, a Yale-educated, board-certified diagnostic radiologist who's been looking at MRIs for his entire career for decades. Absolutely not. No. there's no brain damage in Mr. Davion Murphy's brain. He was exposed to repeated violence in his childhood and young adult life. There's no evidence of that, folks, for Davion Murphy. None. His mother, Miss Beeks, a wonderful mother, described as a wonderful mother. When asked by Dr. Werner, the state's own expert, last Saturday, tell me about your childhood. I had a great childhood. I had a good mother. And we saw that in the record evidence that Dr. Eisenstein testified about that was provided to him by Ms. Toomey, by Davion Murphy's attorneys. And we saw it in the records, the things she did for her son, the things she tried to do, moving him to a different, getting him out of the 8th grade because he was having all of this conduct issues, which was the support for Dr. Werner's conduct disorder diagnosis, the precursor to antisocial personality disorder. Get him out of the public schools, put him into that Christian academy, and sure enough, what happens? He graduates from 8th grade. It helps him. Later, he fails 11th grade, and he ends up in the Jacksonville Youth Academy, where he has to go to school, and he finishes 11th grade. And then what happens? His mother, who kicked him out of the house because she had exercised some tough love, which takes a lot of love. For any parent knows that. It takes a lot of love to kick your son out or kick your daughter out when they're doing something like that and not being accountable. He was skipping, smoking, gambling, getting into all kinds of trouble at school. She kicked him out of the house and he went to live with his one of his grandmothers. But in 12th grade, after he graduates or gets through 11th grade, she goes and petitions the high school there in Jacksonville and gets him back into school, and he finishes his 12th grade year. He doesn't graduate with his class. He later gets his special diploma for high school. There was no violence in his childhood. This is a young man who learned how to work. He learned how to work a 9-to-5 job, and we saw that in the evidence. All the jobs he held for months and months and months. In fact, he taught his younger brother, who was transported down here from prison to testify for his older brother, and told you, he taught me how to work a 9-to-5 job. He taught me how to be responsible. And what else did that young man tell you about his older brother? That Davion, at 8th grade, 13, 14 years old, when his mother had to be hospitalized, when Miss Beeks had to go in the hospital, this defendant takes over. He takes over the household. He takes over the chores and making sure the other siblings do the chores and keep the house up to the standards that are Miss Beeks' standards. He cooks for his siblings. This defendant, just like the other defendants, had a loving environment around him with caring mothers, caring people, other than Rashad Murphy's mother. I wouldn't put her into that class, apparently. He's not in the borderline range of intellectual disability. He's in the low average range, but not in a range that disables him or keeps him from being able to work or keeps him from being able to recognize the fact that he needs to avoid the ring camera at the Airbnb the day before, or keeps him from understanding that when they're committing this murder, in order to keep the victim from knowing they're there and taking off and fleeing, that he needs to conceal himself and hide behind the cars and take up a position, because you remember, he was the backup singer in this performance. He was the backup shooter to prevent flight as a hedge against the victim escaping. And he sure fulfilled that, didn't he? He came out of the shadows with those giant fireballs coming out of that 300 blackout. And it didn't prevent him from understanding that he needed to hide his identity. He needed to wear dark clothes to stay camouflaged in the darkness of that night, and he needed to hide his identity with a ski mask. You didn't really probably need Dr. Werner to tell you all of that. Davion Murphy grew up in a household marked by instability and financial strain. I don't know about the instability. There probably was financial strain. I think that the young man yesterday from the prison told us when he was being questioned, it's not like we were living in some mansion or something. So yeah, I mean, it was a caring, loving environment, but we didn't have a lot of money. He didn't have a stable male role model in his life. Maybe. His father was diagnosed with schizophrenia. Well, his father really wasn't in his life. His father was in prison for a lot of his life. You heard his uncle who came in and testified about Davion's upbringing. His father was incarcerated for life when he was 12 years old. Yeah, is that mitigating? Probably. Yeah, I'm sure that had some effect on him when he was a boy to lose his father like that to prison. He took on a parental role. Well, we just talked about that. That basically contradicts the mitigator that he has borderline range of intelligence. He's loved by his family, no doubt about that. No doubt about that. And the existence of any other factors. I want to go back real quick before I leave Rashad Murphy, because folks, unlike the guilt phase of this trial, I'm not going to have a rebuttal argument. I'm not going to get up here again. The way this works, since we are seeking to have you sentence these defendants to death and their lives are on the line or at play, their attorneys, and the state doesn't quarrel with this at all. We don't quarrel with this. They get the last word, all right? They get the last word. But I want to talk about Rashad Murphy one more time. There was something I didn't speak about earlier that was significant in that mitigation. His aunt told us that the grandmother and the aunts wanted to help him to pursue his passion. That Rashad Murphy was a successful football player. He excelled. And they let him go to live with a relative in New Jersey to play on this team up there, this high school team, to give him that opportunity to go up there. She said there was a video, and I think you all probably know what they're talking about. They make videos of highlights to try to get kids into college on scholarships. That's what these people did for that young man. That's how loving and caring they were. I just wanted to mention that before I forgot about it. When you're considering the weight of these mitigating factors, please consider what's also been proven alone in the mitigating factors, that all of these defendants had people in their lives that loved them, cared about them, that were role models for them. They never went without that. None of them did. Both the Murphys, Mr. Gathright, Mr. Chance, Mr. Gathright and Mr. Chance, both of them had every opportunity to grow up to be productive men and citizens. So I want to talk to you about weighing aggravating circumstances versus mitigation. Well, I'll come back to that in a minute because I want to talk about this aggravator, and I've been up here for quite a while. These three defendants, the three shooters, knowingly created a great risk of death to many persons. Knowingly created a great risk of death to many persons. And I want to go through this with you one more time. I'll try to be quick. Look at where Mr. Rashad Murphy is firing that fully automatic Glock pistol. He's not just firing it in the direction of that charger. Right behind it lays Armani Turner's Hyundai with Miss Randolph in it and Mr. Howard in the back seat. He knows that his rounds may go anywhere over there. He's creating and knowingly creating a great risk of death to many people. He knows that there's people in that other car, the Altima. That doesn't stop him from firing. And when they came into this parking lot and drove all the way around that whole complex, every one of those defendants that were involved in the shooting, the Murphys and Mr. Gathright, saw all of the cars parked in the parking spots. And we know from the evidence that hotel was full of people, and all of them knew it. And Mr. Murphy, look at the indiscriminate firing into multiple cars with all these party goers. Has that been proven beyond a reasonable doubt? Absolutely it has, as it pertains to Mr. Murphy and that fully automatic pistol that he's shooting 31 rounds out of. You see the impacts here to this car. It's the state's assertion to you that is now Mr. Gathrights rifle fire coming in, and we know the 2 rounds coming out of Mr. Jones' bodies come from that rifle that Mr. Gathright is fired. And again, I pointed out to you earlier, watch the rear window of the Altima. Lights come on. Camilla Bentley's trying to get out of there. You heard her in her testimony. As soon as the car moves, first impact. Second impact. 2 impacts. That is Mr. Gathright, Sean Gathright. He fired that AR-15 into that Dodge Charger, and then he redirects directly into that Altima. And as far as he knows from his position at Truth 18, there are many people, at least 3 in that car. Tafa McCrae and Miss Albritton and Miss Camilla Bentley. And that didn't stop him from firing into that car, into both of these cars. He knows Gino Norris or Xavier Edwards is in that Charger. We're talking about multiple people being fired upon here. A knowing commission of great risk to many people of death. Absolutely, it's been proven in this evidence. And if you look at the next video, let me move to it real quick. First of all, I guess we can look at these people that were being affected by all of this. Miss Turner, Miss Randolph, Mr. Howard in the back seat. Tafa and Aaliyah are now in the lobby using the restroom, but these 3 don't know that because they've been around the corner hiding. And they left to go into the lobby. When they went in there, it wasn't at a time that the cruise was driving by with Mr. Chance to be able to tell them that. So as far as they knew, these cars had all of these people in them. Then the other video of the shooting. Okay, Mr. Gathright is now firing into the Charger. Watch his muzzle of that rifle. Right there. He turns and redirects his fire into the Altima. No hesitation. None. He knows he's firing into cars that hold multiple people, and there's absolutely zero hesitation on his part. No cause for concern. Continues to fire until now the Charger starts to move. You see its headlights in the lower left corner. He's still firing into that car. And now comes the Charger, so he redirects fire into them. Now, beyond these cars is 40th Street McKinley. 40th Street McKinley, a busy road, and he's firing towards that road. Indiscriminate, with impunity, doesn't really care about anyone that could potentially be driving over there. Continues to fire, and then is firing there at the car as it's going north. His fire is going northwest. If you remember in the evidence, and you can see where the Honda Suites is. I'm sure you all are familiar with this. You've looked at it for weeks. But you remember, if you look at the direction just to the left on the bottom of the portico, you can see the tree at the end of that little island. You can see the handicap spot where the Lexus was parked at the time. Mr. Gathright is directing his fire at that Charger as it's passing him, and he's firing now to the northwest, right in the direction of that La Quinta Inn, where Pedro Gabor was staying with his wife and his 10-year-old son and his 6-year-old daughter, here from Ocala to go to the Lowry Park Zoo, And Mr. Gathright, he doesn't care. He's not stopping. There's no cause for concern. He's opening up with a 5.56 NATO caliber high-powered rifle, and he's firing it directly into the path of that Holiday Inn and that La Quinta Inn. And we know that was a high-powered round that went through that air conditioning unit, through that brick wall, coursed across that room, and struck Pedro Gabor's wife in the ankle, and it was stinging her. She didn't know what it was. And then it was his little boy the next morning that found it, the one piece of projectile. Later, a uniformed officer went in there and recovered more from that round. That didn't stop Mr. Gathright. Mr. Gathright was firing indiscriminately right towards all of this densely packed humanity. Having driven around that parking lot and seen all those cars, knowing that this is a hotel complex, you saw the big signs outside. There's no mistaking where they were. And that's in addition to all the rounds that he and Rashad Murphy pumped into those cars towards these party goers and friends. And now we get to Mr. Davion Murphy. Who incidentally is not going to be reflected on this, but when he comes out of the shadows by that yellow Bronco on one side and the Mercedes SUV on the other, he's firing into the Dodge Charger, but he's also firing directly in towards the hotel. Sean Gathright was directing fire into that hotel, and we saw that there were windows shattered in the front of the hotel at the entrance of the hotel. Could have been anybody in that hotel behind those windows. And that's just in the front of the hotel. Look what he's doing here. Look what he's doing there. He is firing. He's firing directly up to the left in that image of that hotel, straight up there, pushing those rounds rapidly with that firearm that he has no stock on it, right? And he's firing it directly to the northeast, up that corridor where the Charger is fleeing. He didn't care. It didn't stop him to think that there are hotel rooms lining that west side of the hotel. And we heard Audra Agramonte tell us, remember her, the woman who came here from Palm Beach County with her husband and her daughter and her daughter's boyfriend. They had put the daughter into, or checked her into her dorm for summer session at USF at the University of South Florida. And her and her husband and the daughter's boyfriend are in the room, and they hear all this shooting, and then a round flies through the window and cuts across the room, the boyfriend grabbing her and pulling her to the ground. That defendant it didn't stop him at all. The fact that this was a packed hotel. He's firing indiscriminately down the edge of that hotel. I just want to point out one thing, and it really shouldn't be any of your all's concern at this point. You heard a question asked of Dr. Eisenberg whether Davion Murphy is right or left-handed, and they said he's left-handed. Okay, that had nothing to do with Dr. Eisenstein's opinions in this case. Zero to do with it. All right. So one thing you can be assured of in this case is that your guilty verdict rests on mountains of evidence. There should be no doubt in your mind. That's already been proven. That's already been proven. But it's clear in that video that Mr. Murphy is holding the gun with his right hand, not his left hand. And there's a reason for that. Because if he used his left hand, there's nowhere to put his right hand because of the brass catcher. He'd be right up on the muzzle if he did that. There's a reason he's using his right hand. It's out of necessity. And of course, we know Mr. Murphy, he's not embarrassed, he's not shy, and obviously zero remorse over what he did, his role in this case, because he's reenacting it in the interview room, mocking the police with what he did. That aggravating factor alone, placing many people at great risk and knowingly placing many people at great risk of death. Think about that. Think about how heinous that is. How heinous that is. That you're going to treat all the people in that hotel, all the party goers, as just fodder. They're just fodder for these killers because they're going to kill Charles Jones no matter what. And that's why they brought that overwhelming amount of firepower, and they were going to lay down a barrage, a wall of lead. And anyone that got in the way, it didn't matter to them. It didn't make them hesitate. They had zero reservations in the evidence about that. And that is an aggravating factor. That is an aggravating factor. When you couple that for these three defendants, the Murphys and Mr. Gathright, with the other aggravating factors in this case, the cold, calculated, premeditated fashion this murder was committed in, there is absolutely no contest between the state's aggravating factors and these mitigating factors that have been presented to you. None. The law on weighing aggravators versus mitigation. First, you decide what value, what significance in light of this case and how it applies to the sentence. What significance does that mitigation have? The aggravation, all of it is powerful in its significance. The state would suggest to you that every aggravating factor is a powerful factor as it relates specifically to this case and these defendants' individual actions. You have to do the same with the mitigation. You have to go through and determine, number one, has it been proven? Number two, what weight does that have to me and my decision making in this case? Does it have significant weight? Does it have great weight? And then ultimately, it's up to you to decide. And it's not a numbers game. It's not a numbers game. It's a quality game. It's the quality of the aggravation. Now, you have to decide, does the state's aggravation outweigh their mitigation? Because if it doesn't, then your job is done. Your personal decision is done. You check off life. That's your vote. If it does outweigh the mitigation, then you can sentence them to death. You remember that all the way back, the jury selection. And it's the state's suggestion to you, each of you individually, that the aggravating factors in this case prove to you, they should prove to each and every one of you that the just verdict and just sentence in this case is one of death for each of them. For each of them. I want to go back to the cold part of the cold, calculated, premeditated. We talked a lot about the premeditation. We talked a lot about all the individual steps. I've discussed with you all of the problem solving that went on. But I want you to consider how cold-blooded a conspiracy that lasts for weeks is. How cold-blooded that is. Look at the accuracy and the efficiency with which Sean Gathright operated in this murder, with which Davion Murphy operated. No hesitation at all in anything that Mr. Davion Murphy did. From the time he came out of that car all masked up, had his mask on, had his disguise on, keeping himself hidden away in the shadows until the appropriate time when he came out and started unleashing those fireballs of gunfire. And then to turn and pursue and that tenaciousness and that purposefulness, and then to immediately turn after firing and go back immediately to flee and to get away. All of this with all of those defendants. Rashad Murphy too. It doesn't just suggest that they all had ice water in their veins. It suggests that they all were acting with cold-blooded lack of any kind of emotion. This was just simple business. From loading that Impala to the way and the manner in which this murder happened, it was all business. They acted as a team effort. You know, this kind of premeditation that you see in this case, this is a kind of teamwork and premeditation that puts rockets in space, folks. That's what this is, and the kind of problem solving. But when you want to talk about coldness and cold-blooded, We already saw the social media posts from Mr. Chance and Mr. Murphy. Don't forget about this. This was right around noon. Mr. Chance comes out of that front door. He's got a celebratory drink in his hand. He walks out. The moving truck is unrelated. That's dealing with the next door neighbors. But he comes out with that drink in his hand. And then he's posting this. He's putting up posts of him standing with his drink. Look at the timestamps. Look at that. That's like around 11 o'clock, 3:31 UTC minus 4 hours, 11:30. What is that, 16 or 1856? So right around 2 o'clock UTC, right before they left. He's drinking, he's celebrating and putting up posts online. And then we go back, finally, just to touch upon this one more time, to the conversation, the conspiratorial conversation that's occurring weeks before this between Rashad Murphy and Sean Gathright, the 18-year-old. We got to stop Chance from giving us away, from revealing what we're doing. Get on there and stop him. And they agree to do that. We talked about the business-like attitude of Mr. Gathright and Mr. Chance. We've looked at that video, so I'm not going to go through it again. Folks, back in my opening statement, I told you that during this trial in the guilt phase that we were going to reach out into the darkness of the early mornings of June 23rd, 2024, and we were going to drag that conspiracy in here and reveal it under the lights of this courtroom, the bright lights of truth. And that's exactly what we did in this case. That's what the evidence in this case did. It showed and revealed the underbelly of this evil, wicked, pernicious plan. But it was more than that. You know, I talked to you earlier about piling on in our evidence. There must have come a time in the last week of the state's case where you all must have been thinking, man, when is this going to end? We've heard enough. This is well beyond a reasonable doubt. When is it going to end? When's this evidence going to end? It just keeps coming. And I wouldn't blame you for having that thought, because it did. Because along with us dragging that conspiracy in, it was like a dump truck coming in here and earth movers just pushing in this mountain of premeditation. You know, and it really, the way it ended up being here when we were in guilt phase closing statements was like we were all floating around in this ocean, literally an ocean of premeditation. Literally. That's how much evidence there is in this case. And just like those fireballs coming out of that 300 blackout in that early morning right there by the portico of the Home to Suites, from Davion Murphy's gun that were so bright, even in that ambient lighting of that parking lot. Just like that, this evidence shines brightly. It can't be avoided. It can't be hidden from. No hoodie, no COVID masks are going to hide the defendants from this aggravation. There are no Ubers here to whisk anyone away from your sentence in this case. There is a mountain of evidence proving these aggravating factors. I point that out to you because it gives you, each of you, this benefit when you go back there and you're deliberating and you're voting on what the appropriate sentence is for each one of these defendants. It gives you the assurance. It gives each of you the knowledge deep down, that your sentence is based upon not just a rock, like it says in the scriptures, not just a rock. It's based, and it sits on this giant, enormous mountain of evidence of premeditation, evidence of creating great risk to many people, and the gang membership that lies at the heart of this case. All of these aggravators, there are mountains and heaps of evidence that prove it. None of you should walk out of here after you enter your sentences and your votes. None of you should have any qualms or doubts about doing so, because you can go home and you'll know that night in your heart that your vote to sentence these defendants to death, your vote stands on that evidence and that assurance. And you can have that assurance that night. You can be assured of that, of the correctness and the justness of that sentence of death the next day, through the weekend, into next week, into next month. For the rest of your lives, you can know that your sentences in this case are just and right sentences. I quoted earlier from the book, To Kill a Mockingbird, from Atticus Finch, describing in his closing statements that the courts are the great leveler. The courts are the great leveler. I want to quote another writer, a writer from the 19th century, from the 1800s, Robert Louis Stevenson, who wrote those wonderful books, Treasure Island. I don't want to misstate The Strange Case of Dr. Jekyll and Mr. Hyde, stories that we've all heard in our lives. He was a great writer. He was a poet. He was a national hero in Scotland and is still revered there today. But he's also known for this quote: eventually, everybody sits down to a banquet, a banquet of consequences. And today, each of these defendants, all of them sitting over here, are sitting in this courtroom for their banquet. The state of Florida stands before you and requests that each and every one of you go back there and vote to sentence each of these defendants to death for the murder of Charles Jones, for the murder of this man, that you sentence each of them to death, knowing that it is the just and it is the right sentence in this case.
All right. Ladies and gentlemen of the jury, it is 4:37, and as I indicated, one of you has got something important to do this evening, so we are going to recess for the night. We have one more day ahead of us. Just remember, again, it's critically important that you don't talk to anybody about this case. Don't read, watch, listen to any news accounts or social media posts. Don't do any independent investigation. Tomorrow, I need you all just to bring with you, again, just in the event you have to be sequestered, just a little bag. My experience is that when it comes to penalty phase deliberations, because it is at the end of the day an individual decision, they normally don't take as long as guilt phase, but you never know. So we do need to be prepared that if you're not done deliberating by the time it gets whatever time tomorrow and you feel like you're no longer being productive, that you do have a bag with you or something that you can take in the event you do have to be sequestered. Also, 3 of you already know that you are alternates, and on behalf of everyone involved, I can't thank you all enough for your service. 2 of you, however, do not need to return tomorrow morning, but you're not excused yet from your service. So specifically, our alternate juror number 213, Mr. Initials JM, and juror 220, Miss Initials KC. You all do not have to report in at 9 o'clock, but I do need you to be available in the event something happens, and we have to have one of you step in. All right. So my judicial assistant will contact you right around 9 o'clock. If everyone shows up and we no longer need you as alternates, she will call and let you know. If something does happen and we need you, then I'll need you all to be able to report immediately to the courthouse. So that's why you're not being released yet from your jury service, all right? But if she calls you tomorrow and says, thank you, your jury service is now completed, then you are completely released, okay? Our alternate number 1, which is juror number 168, initials Mr. MN, you will need to return tomorrow morning at 9 a.m. Okay? Okay, very good. Then we will see you all at 9 a.m. tomorrow morning for the defense closing arguments.
All rise.
Low key, niggas hating, but they don't want no beef. State gang, true sippers, bitch, I bet we don't eat.